In the recording. Hello. ऋतु रानी है।
Good morning, friends. There is some technical issue. That's why there is a delay in starting the lecture. So just bear with us for 5 minutes more. Thank you.
सर सुन पा रहे हैं? हेलो
हेलो, यस।
सर आवाज मेरी आ रही है?
आवाज तो आ रही है। सर, आपने क्या नाम से ज्वाइन किया?
ब्रिज मोहन करके ही शेयर किया हूँ।
ब्रिज मोहन से, लेकिन यहाँ पे दिख नहीं रहा है आपका नाम। एक मिनट, मैं देख लेता हूँ। हाँ, अभी आपकी शेयर हुई है सर। एक 5 मिनट में हम लोग चालू कर देते हैं। अभी यस, वी कैन सी योर दिस।
हाँ
2 मिनट सर, 2 मिनट सर, हो रहा। 1 मिनट। ओके। Very good. Very good morning to all of you. Am I audible?
Yes, sir.
Yes,
Am I
sir.
audible? Yes.
ब्रिज मोहन जी,
Yes, sir.
अरे नहीं हो रहा है, क्या प्रॉब्लम हो रहा है भैया?
Sir, already started a meeting. Jadhav sir का wait कर रहा हूँ मैं.
Hello.
Sir, shall I start?
Sir, am I audible?
हाँ हाँ आ रहा है
आ रहा है ना?
Yes,
Okay.
please start.
Sir, I have immense pleasure in welcoming Breej Mohan sir because he's a very special person to us. He has served Indian Navy for almost 15 years. And after serving in Indian Navy, he has joined New India in 2017. 2017, and after that, within a year, he has completed fellowship. And since 2017, he's been working with motor TP department. So he has in-depth knowledge in motor TP. He has a blend of theoretical knowledge as well as actual practical knowledge because he's working with the TP department. And the important thing which I would like to tell you about Breej Mohan sir, the maximum views. All the lectures which were conducted by BVKS in the last year, the maximum views on YouTube Breej Mohan sir has got for his lecture. So I welcome Breej Mohan sir, and I hand over Breej Mohan sir, so he will share his knowledge and expertise in the motor TP department. Breej Mohan sir, all to you. You can start your lecture.
Thank you, Anil Jadhav sir, and thank you, BVKS. Good morning to everyone. Giving us the opportunity to tell you something about the motor third party. Yesterday, Pratik sir has taken the wonderful class of motor OD part. So second section is motor third party liability. So I am going to cover whatever I have done, whatever I have experienced in the last 6 to 7 years. So the technical hitch that my laptop is not working. So sorry for inconvenience. And we'll try to conclude. Just
Voice is low, sir.
the interactive section. It should be the interactive section. Your participation is required. And whatever the leftover after the OD section, any questions, 4, 5, 6, whatever the part of CP section, I will be very much happy if it is coming with my this presentation. I don't
Your
have
voice
much-
is very low, sir.
I can say I don't have any experience of the promotion exercises. But
Sir,
I have
your
covered
voice is
entire
very
CP.
low, sir.
Yes,
Sir,
sir.
your
Voice is not
very
clear,
low.
sir.
Your voice is not clear, sir.
My voice is not clear now.
Now okay.
Now it is okay.
Okay. So I'm trying to cover all the aspects of motor third party claim, which have motor after the motor OD section, whatever leftover is, I'm trying to cover. So we will go one by one without wasting any much time because we have already passed 15 minutes. So today we are going to cover these are the first some introduction section is there. Some 1 or 2 questions, one question hardly making from this. Then we'll move ahead for type of motor third party
Your
claim.
voice is not clear, sir.
Voice is very low.
So you can use mic.
Okay, just a minute, ma'am. Just a minute. Now my voice is clear. Hello.
Hello, sir. Your
Voice is
voice is not louder. It's very. It's not clear actually. So can you come closer to the mic and speak, or otherwise you will have to use a different mic because maybe there may be some issues with the laptop mic.
Okay. Sir, whether my voice is clear now or not?
Now clear, sir.
Clear, sir.
Now very much clear.
Okay. Just a minute. Just hold on. So today I'm going to cover our introduction part, then the type of motor third party claim, whatever compensation is to be paid in the different type of motor third party claim. Then the one judgment has came, National Insurance versus Pranay Shetty, that has made the calculation simple. Then we'll go ahead with the Motor Vehicle Amendment Act that came in 2019, but still some implementation part is still awaiting. Court is still following the earlier this thing. Just a minute. Then we'll see something brief about the driving license. What are the latest amendment? Then the definition, some definition is there. Other important sections of Motor Vehicle Act. Then the Consumer Protection Act 2019, and finally the Ombudsman. Are you listening, man?
Yes, sir.
Yes, sir. A screen is visible?
Yes, sir.
Yes, sir.
Okay.
Yes, sir.
So this motor third party introduction part. In India, Motor Vehicle Act was first enacted in 1939, and that the this Motor Vehicle Act 1939 only made the third party insurance compulsory. As per the recommendation of committee and expertise that has been appointed by GIC in 1985, the Motor Vehicle Act was amended in 1988, which came into force with effect from 1st July 1989. So this question might came 1st July 1989 when the Motor Vehicle Act 1988 uh, was implemented. So this was implemented in on 1st July 1989. So now we are talking about the Motor Vehicle Act. So once we are talking about the Motor Vehicle Act, we are only talking about the Motor Vehicle Act 1988. Act was again amended in 1994. So
Excuse me, sir, the screen is not visible.
the screen is not
Visible,
visible.
ma'am.
It's
Visible,
visible.
visible.
It's visible.
Visible, ma'am.
It's visible, sir.
No, next screen is not visible. It's only
It's
topics to
visible
be
next to
covered.
not.
There is a issue with my this thing.
No, sir. The screen is visible to us.
The screen is visible.
We can see the screen, sir.
So
Screen
your
is visible, sir.
Slide is not moving.
Change the
Slide
slide,
is not
change the slide.
Just hold.
so you have to take control. If it is uploaded by somebody else, then you have to take control.
No, I have a control, ma'am. Only thing is that I have login with two devices, so that might be the issue. Sir, which screen is here? And the introduction, the next
Sir,
slide
try
is there.
shifting the slides.
Now the third party claim.
No.
Screen is going to be changed or not, sir?
It's not
Not
changing, sir. First
It's not
screen.
changed, sir.
It is not changing.
Yeah,
It's not
first
changed.
screen.
Okay.
We are on topics to be covered slide, sir.
Okay. Now which screen is there? This one, huh?
Screen is visible. You go to the slideshow and start slideshow. Hello, sir.
Just a minute, sir.
Uh-huh.
Anil sir, can we plan this meeting after some time because there is a technical issue?
Okay, you just try to solve it. If it is possible, we can wait for 5 to 10 minutes more. Otherwise, we'll have to reschedule. If it is not happening, then we'll have to reschedule it.
We'll reschedule maybe in afternoon session, sir, if it is possible.
Uh,
I am trying to resolve it within 5 minutes. If
Okay,
it is
just
not
try to
going
solve
to
it.
happen,
If it is not happening,
yeah.
then we can reschedule
Okay.
it. Just try to solve it. Yes, sir.
So you have to disconnect it and re-log in again. Then it might be solved.
Okay. Am I audible now?
Yes, sir, you are audible.
Okay, just please. Now the first slide is
Yes, now the first slide is visible, sir. Try to move
there.
shift it to the second slide.
Voice is also clear.
Yes, voice is also clear.
Yes, sir.
Now move to the third slide, sir. Just try. Yes, it's happening now. It's happening now.
It's happening. Actually, sir, I have connected with one laptop for sharing my screen, another for my voice audio.
Okay, that's
this is the main issue. So I was talking about the introduction part. So I have completed that the Motor Vehicle Act 1988 came into force from the 1st July 1989. So again, the act was amended in 1994. That time, section 163A and 163B were added as on the structural formula, where we'll see the various aspects of 163A and 163B, where this thing is negligence at the part of anyone is not required to be proved. So again, the act finally was amended in 2019, and it has came into effect from 9 August 2019. So date is not mandatory from when this was amended. Whatever the aspects of the amendment that we need to come to know, because so many data is there, we need to learn how much compensation is going to be paid, that we need to learn and mug up, because question may came from there. But the first date, 1st July 1989, that is the important. Some question I have seen in the model set and all. So please note, the Motor Vehicle Act, as I have told earlier, it was amended in 2019, but some notification has already came on 9 August 2019, but still the implementation is awaiting. Some part of the implementation we are seeing that the DL is now being issued as per the latest amendment, fine is being implemented as per the latest amendment. But before the court of law, they are still following the Motor Vehicle Act 1988. This is just for the information. So now, type of the TP claim, which is arising out of the use of motor vehicle. So there is a two forum, we can say the three forum. One is the Motor Accident Claim Tribunal, another is the Employee Compensation Act, Labor Court, Industrial Court is there, and the one aspect is hit and run. So hit and run is not come under the purview of any court. It is directly application is being filed before the district collector or whoever appointed by the district magistrate. So and this fund is being maintained by Solatium Fund. We know. So this hit and run is there. We see what has the latest amendment as for the compensation for hit and run cases where the vehicle is not being traced, identification of the vehicle is not uh, traced by the police authority. So in MHT case, there was four section claim application is being filed under this four section. Most important section is under section 166, where the unlimited liability is there. We are talking about the unlimited liability. This unlimited liability, if you see the broader aspects of unlimited liability for the third party injury, whether it is fatal or injury, it is applicable everywhere in all the kind of insurance, in the all the stream of insurance. If the liability uh, for the injury or for the death arising out of the use of any kind of, whether it is aviation, whether it is marine, so it is differing from the you can say the earning capacity of the citizen. If you say someone is residing in US, so see he or she must have the more earning capacity because the developed country is there. So accordingly, we are making the aviation and all the liability cover. So that is the other aspects. We will focus on the Motor Vehicle Act only. Another section is under section 164. Earlier, it was known as the section 163A, 163 alpha. So this is no fault liability. Again, under section 140 is also the no fault liability where fault is not required to be proved. And then the third party property damage, TPPD. We'll see what are the compensation is being given by the court, by the or either the settlement court is awarding as per this calculation. So section uh, everything is going right, sir? My voice and the PPT?
Yes, sir.
Okay. You can stop me anywhere if you have any query at any time. And let me this training lecture should be the interactive. So section 140, NFL, no fault liability. Latest, as per this amendment, it has been omitted. Not only section 140, the entire chapters from the section 140 to 144, the entire chapter has been omitted. So, but still we are getting the court order for this no fault liability. So, what are the compensation? Compensation for 50,000 for fatal case and 25,000 for injury case. You all may be aware of this fact, and question might be come from here, but now some other data is also there. So hit and run, now the section 161 of Motor Vehicle Act is there, where earlier it was the very too low compensation. It is only the 25,000 for fatal and 12,500 for the injury. So we can see the multiple enhancement in this hit and run cases. That is a good initiative, and we can say it is required. So rupees 2 lakh for fatal and 50,000 for grievous injury. This hit and run cases. And section 164 is also amended as per latest amendment of 19. Earlier it was known as the 163 alpha, where the provision for the minor injury is also there. But after the amendment, this minor injury is not there. Only two aspects is there. One is for the fatal injury, it is the 5 lakh rupees, and for the grievous injury, it is a 2,50,000. So we'll see what are the earlier provision. Earlier provision for the grievous injury, if someone is having the disablement, suppose 40%, so he will get the 40% of the 5 lakh rupees, not the that is the 2 lakh only, not the 2,50,000. That was the earlier provision as per section 163 alpha. And there is a Minor injury also provision, that is only 25,000. If question arises, what are the compensation for minor injury under section 163 alpha, you need to answer 25,000. But if it is asking for 164, section 164, so there is no such provision for minor injury, or you can say the only injury. It is only for grievous hurt, that is 2,50,000. Moving ahead. So third party property damage. You have which slide subjected to insured or the other slide? Which slide is being this thing? Can anyone?
TPPD one and the employees compensation 1926.
Yeah.
Okay. So I am seeing this slide. TPPD. So third party property damage, it's for applicable two-wheeler it is 1 lakh rupees and all other vehicle it is 7,50,000 rupees. It is a maximum cover. But if the insured has restricted his third party liability, third party property damage liability for 6,000, so this amount is not applicable if he has restricted his statutory third party property damage liability. If question arises, what is the statutory third party property damage liability? That is only 6,000. But there is a provision that we can cover for two-wheeler, that is for 1 lakh rupees, and all other vehicle for 7,50,000. Yesterday, someone has asked the question before the court of law that the unlimited liability for third-party property damage is there. So let me clarify this thing. Before the law, some judgment may came or may be pronounced by the thought process of the judges. But as per law, this has not the unlimited, and it should not be the unlimited, because whatever the property damage in the case of OD or in the case of other stream of our insurance, we are covering the property as per the value of the property, as per the value of the stock and other things. So it should not be the unlimited. It is restricted. It is a capping of 1 lakh and 7,50,000. And minimum statutory liability is 6,000. Is it clear? Should I move ahead?
Sir, sir.
Okay. Yes, tell me.
Hello.
Tell me, sir.
Sir, excuse me. Hello. जो अभी आपने सेक्शन 163A अल्फा के बारे में बात की.
Right, sir.
Now section 164, 5 lakh and rupees 2,50,000.
Right, sir.
Kindly explain once again about alpha.
163 alpha, there is amendment in 2018. I will show you the end of the slide what are the provision in that that I have put in the screenshot of 163 alpha.
Okay.
One is the 5 lakh rupees for fatal injury, another for the disablement, permanent disablement. What are the percentage of disability of 5 lakh rupees for injury if it is converted into permanent disablement? And there is also provision of 25,000 rupees for minor injury.
Okay.
So that provision has not changed, and there is no scope for minor injury. It is only saying a straightway 5 lakh rupees for the fatal, and if it is a grievous hurt. So how we come to know it is a grievous hurt? There is a section of IPC, Indian Penal Code. That section is 337 and 338. We'll discuss later. 337 is charge against the accused for the minor injury, and 338 is for the fatal injury. Grievous hurt or grievous injury. So if you see on the charge sheet of a police paper, in that case, if 338 is there, so it's a grievous injury, and the claim can be payable for 2,000 2,50,000 for the under section 164. Is it clear, sir?
Clear.
Okay. Now come to the Employee Compensation Act 1923. There is a latest amendment in 2017 which came into effect from 15 May 2017. Year you should know when the amendment has came. Motor Vehicle latest amendment is there in 2019, and this Employee Compensation Act is 1923. Another aspects, the this Consumer Forum also has been amended. I think it is in 21. I will see you the letter on the slide. So there is under Employee Compensation Act, I have highlighted this thing. Applicable if personal injury is caused to an employee by accident arising out of and in the course of his employment. There is no mention or. If it is a or arising out of or in the course of employment, claim will be some different. But clearly it is mentioned for the normal employee compensation also that we are issuing the WC policy. There also it is there. It should be arising out of and in the course of employment. Sometimes the insurance company is we are receiving the claim petition where there is a no clarity whether this accident occurred out of the employment. There is a course of employment that he was on duty, but whether that accident occurred arising out of that the course of arising out of that employment, that is not clear. Suppose I am giving one example. One driver has died on the wheel of a private car in parking. He might have suffered the heart attack or some kind of something, but vehicle was parked in the latest we have received the summons in their private car it is, and he is a traveler. The vehicle was being traveled under a travel agency. There is no earlier fatigue. There is no earlier this thing. So many booking of that the driver. He has the first booking in the morning. He came to the came with the who has hired the vehicle and leave him and park the vehicle in the parking to get him at the evening. So this is a natural death and where the claim can be disputed by the insurance company because it is not arising out of the employment. He is on the employment. It is during the course of employment, but not the arising out of the employment. So that is clearly mentioned in Employee Compensation Act that the accident should occur. It is arising out of and in the course of employment. Is it clear, sir?
Yes, sir.
Okay.
Yes, sir.
So now what is the compensation under Employee Compensation Act? It's a for fatal injury, 50% of monthly wages multiplied by the relevant age factor. And in the injury case, 60% of the monthly wages, the relevant factor, whatever the age factor, and the disability, permanent total disablement. And it should be the functional disablement, not the physical disablement. Physical disablement is superseded by the functional disablement. If a driver, suppose a driver lost his lower limbs, one level lower limbs, so he is not able to drive the vehicle. He is driving the transport vehicle, so he is not able to drive the vehicle further. So functional disablement in this case is 100%. Question will not come in that case in this regard, but just for understanding, I am telling the disability that should be the functional disablement. It will be the final. In the case of injury, it is a compensation. What are the 60% of monthly wages into relevant factor? So factor is ranging from 228.54, that is the highest factor for 16 years old, or as the age is growing up for the injured or for the this thing fatal case. The lowest the factor is 99.37. So one thing is it should be the clear for this thing.
Minimum compensation is also I have mentioned. For fatal case, it is 1,20,000, and for injury case, it is 1,40,000. So minimum multiplier is 99.37, and maximum multiplier for 16 years of age 228.54. So you should remember this, the minimum and the maximum. Monthly wages has been revised with effect from 3rd January 2020 by the notification.
Sir.
Earlier it was the 8,000. Now it has
Excuse
been
me, sir.
revised by the. Yes, tell me.
This is 1,20,000 is minimum or more maximum?
No, it's a minimum.
So you
If
have
you
given
are
whichever
to
more.
calculate, if you are going to calculate, you will see in the fatal case always it is more than the 1,20,000. But in
Okay.
any case, it has been mentioned as per the factors. No, it is mentioned in the this thing notification.
Clear, sir,
1,20,000 for the, it is a minimum. Here it has clearly mentioned whichever is more.
Yeah, got
If
it, sir.
50% now, 50% is less than the 1,20,000, so you need to pay the 1,20,000. So 1,20,000 and 1,40,000 is minimum. So under section 166, am I clear? Your slide is saying?
Yes, sir.
Okay. So under section 166, where there is an unlimited liability, and it totally depend. Most of the outgo in third party claim, if I say, is there in the under section 166, because the compensation may arise from starting from the 30,000, 40,000 in injury case, minor injury case, up to 2 crore, 3 crore, 4 crore. Latest we have received one award of 2 crore 31,000. That the individual was earning 80,000 as a team leader in Asian Paints. So we'll see what are the aspects under section 160. So calculation, this is the per necessity judgment has came, and it has made so many clarity on this, how the compensation is being calculated, and what should be the minimum, what should be the actual compensation, what is the implication of future prospects, the future earning capacity of individual. In case of bachelor, what is the dependency? So many aspects has been cleared in 2018 when this judgment, 2017, this per necessity judgment has came. So calculation is multiplier in the WC case, Employee Compensation Act, is being applicable on the monthly income. But here the multiplier, that is according to the age factor and ranging from 5 to 18. So that age factor is applicable on the yearly income. So that is why here I have mentioned this, the monthly income should be multiplied by 12 to arrive the yearly income. So now what is the dependency? Dependency is nothing but whatever the personal expenses is being deducted from the total income. Because in the fatal case, individual is no more, so there is a deduction of personal expenses, whatever there. So it is nothing but dependency. Personal expenses for the various category here I have mentioned. If the died person is a bachelor, so our only parent is dependent, in that case half of the personal expenses has been it is to be deducted. Then the if he has the dependent sibling, any one or two, any dependent sibling, so in that case 1/3 of the personal expenses has to be deducted. So this personal expenses, one minus this personal expenses, is calculated as a dependency. Here I have mentioned the dependency. Here I have mentioned the dependency. So dependency is nothing, one minus this personal expenses for the various category. If he is a married and having a 2 to 3 dependent, 1/3 is to be deducted. For 4 to 6, 1/4 is to be deducted. For more than 6, 1/5 is to be deducted from the to calculate this dependency. So what is the multiplier? We see the multiplier table ahead for the different age factor.
Excuse me,
Yes, sir.
sir.
Anything?
If
Tell me.
the person is bachelor and having dependent parent and sibling both, then
So one third has to be is to be deducted.
okay.
Only parents or only parents include individual also. It is not there. The mother is there and father is not there. Any one of it is there. Only half of the this thing is deducted. Personal expenses. Clear, sir?
Sir, clear.
Sir, if the person is married
Hmm.
and has only one dependent, then
So there is no clarity there. It has mentioned in pernicity dependent. It is to be 2 to 3. So there is a this thing, but normal thought process we are calculating half. But question may not arise from here. It is just for the information. Whatever there in the judgment, a question may arise from there, and because two is there, only wife is there and a husband is there. Suppose the husband died, so it is clearly it's a thought process that the 50% he is expending on himself and another 50% for the family. But if someone is contesting, he is a married and there is no such provision to deduct the half. So court may award by deducting one third only.
okay.
Okay, ma'am. For settlement and all, we are deducting half, but there is no clarity in this on this point. But by law, it should be deducted half. Not by law, by the thought process. Yes, ma'am. Tell me.
If a person is a bachelor and has both the parents, then also 1/2 is
Half,
deducted.
half. Right.
Okay, okay.
Bachelor
Yes,
is
thank you, sir.
so now the multiplier is 5 to 18. We'll see the multiplier table up to the age of 25. From the 15, it is 18. Then the 1 is reduced up to the age of 50. Then 2 slab is reduced up to the age of 70. So we'll see the multiplier table later. So general damage is a non-pecuniary damage. It is not the actual loss, but there is a sentiment. There is a loss of estate, some funeral expenses, actual funeral expenses there. Loss of consortium is there. So as per pernicity, this 15,000 for loss of estate, funeral 15,000, and loss of consortium. There it is mentioned only for the husband and wife. One claimant is only applicable to get this loss of consortium. If he is a married, in the case of bachelor, normally court is not awarding, as per the pernicity, court is not awarding the loss of consortium. But one judgment has came by the Supreme Court after this pernicity in 2021. I think that judgment is telling, for your knowledge only I am sharing this thing, but question may not arise because judgment is not as per this thing. Pernicity is a landmark judgment where we are all the court, all the tribunal is following this. But as per the latest judgment of Supreme Court, all the claimants should get the consortium. This loss of consortium is applicable for all the claimant. If 4 claimant is there, 5 claimant is there, all the claimant is entitled to get the consortium of 40,000 rupees. So that the consortium is known as filial consortium, parental consortium. If a child lost his father, so there is a parental consortium. If a father lost his child, there is a, or mother parents lost his children, there is a filial consortium. So that consortium now it is applicable for all the claimant as per latest Supreme Court judgment. But as per pernicity, if question arises, what is the loss of consortium? So it is 40,000 and it is being revised 10% on every 3 years. So if a judgment has came in 18 and general damage is 70,000, so in 2023 it is 10% increase up to 77,000. Yes, sir, tell me.
Sir, this loss of consortium funeral expenses, loss of estate is cumulative or individual? I mean, suppose a family of 3 is there, so all 3 will get the amount, or individually they'll get the amount?
It is a lump sum amount. It's all 3 will not get the separate. It is calculated as a lump sum. Funeral, loss of estate, loss of consortium. Only loss of consortium I have told as per pertinacity, there is no such provision, but latest judgment is telling that everyone is entitled for the loss of consortium. So general damage for claimant is there. So 4 into 4, 1,60,000 plus this 30,000 is being awarded by the court now. We are receiving the judgment like that. Is it clear, sir?
Yes, sir. Thank you.
So future prospects is nothing but future earning power. If a person having the permanent job and below the age of 40, as per pertinacity, his earning capacity may increase by 50%. So this chart is there. If he is a self-employed or on fixed salary, security person, we are seeing so many security person or person who is on the contract is getting the fixed salary. So for fixed salary, the slab is here. The 40%. If the person having the age below 40 years, then the 40 to 50 it is 30% for the permanent job, and for self-employed and fixed salary 25,000. Between the age of 50 to 60, it's a 15% and 10%. Any queries, sir? Should I move ahead?
Sir, how to calculate monthly income?
Monthly income, we need to get the documentary evidence from the employer.
I mean, the income tax angle is to be taken care of.
Yeah, right. Your TDS or income tax, whatever is there for self-employed, it is this thing that has to be deducted. If this thing income is increasing as per the income tax act, if it is a taxable, and the another professional tax, the monthly professional tax is also is to be deducted from the income tax, from the monthly income or the yearly income. Basically, under section 166, we are calculating the compensation or yearly income. So all the taxes applicable as per the income tax law, it is to be deducted in the annual income.
Thank you, sir.
Should I move ahead? So this is the multiplier chart. So for pertinacity, we are still following the Sarla Verma. There is a clear, I have written for pertinacity. This chart is there in the Sarla Verma case also. So person having an age between 50 to 25, and we are calculating the age as on so last completed age is being taken for the calculation of the for taking the multiplier. If someone is having the 23 years 6 months, so it is presumed he is having the 23 years of age. So up to the age of 50, if you see the multiplier chart, it is, if you see the multiplier chart, it is being deducted by 111. I have written the wrong answer. Sorry. 15 to 25, it is 18. Clear? I will amend this multiplier chart. For 15 to 25, the multiplier is 18. There is error in this slide. Is it clear, sir? Everyone?
Yes, sir.
So multiplier for 15 to 25, it is 18, and it is being reduced by 1 up to the age of 50. So you should not mug up this thing. You should just have an idea.
Excuse
age
me,
is
sir.
increasing.
Sorry to interrupt.
Yeah, tell me, ma'am.
But other people's mic is on, I think. There is a disturbance.
There is a mic. Disha ma'am is there. Ma'am, can you
Sir,
mute?
yes, I am telling you that Geeta madam's
Okay.
mic is on,
Geeta,
I
ma'am.
think.
Yeah, right. She has Geeta ma'am, can you, yeah. Thank you, ma'am. So this multiplier for 15 to 25, it is 18. Then it is being reduced by 111 up to the age of 50. After that, there is 4 column up to the age of 70. So it is being reduced by 2. 51 to 50, 11. 56 to 69. And the last multiplier for 66 to 70 is a 5. 70 plus, it is not, as per the pertinacity, there should not be multiplier. And if a claim is coming, we are negotiating and we are settling as per the lump sum. There is no provision to this thing as per pertinacity. So there is two this thing. I have made this two question for you. Can you calculate the compensation if you are remembering the earlier one? Yeah, should I show you the calculation how it is being calculated? You try for another 1 to 2 minutes. What should be the calculation, and I'm going to show you how much the outgo in this third party claim, how much outgo is there. If someone is earning 20,000, the calculation you will see a surprise increase in the compensation amount. So just try if someone is. I'm giving you 1 to 2 minutes for both the questions. Question is visible to everyone?
Yes, sir.
Can someone read?
The first question, top question is not visible.
First question is not visible.
Yes, sir. First question is not visible, the top line.
First question I am reading. A married person, clearly mentioned, a married person died in motor accident on 1st 2023. He left with 4 dependents, including widows. So her loss of consortium is there. He was having permanent job and earning 20,000 per month. And his date of birth is 1st 6 1983. As per documentary evidence, PAN card or Aadhaar card, anything. Police authority has charge sheeted the accused driver causing death under section 304 alpha. Calculate compensation payable as per pernichety to the legal hires. So how we are going ahead with this question? I am going to show you, because you may not have the experience to calculate this compensation. So after this session is over, you just go to the calculation sheet and see how it is being calculated. And the another question is, a 65 years old driver died in motor accident on 1st 2023 and left with 4 dependents. He was earning rupees 60,000 per month. Legal hires filed application for compensation under WC forum as he was driving. So he has filed the claim on his own vehicle. So calculate the compensation payable to the legal hire. So I'm going to show you how the calculation is there.
Sir, first question is 9,77,000.
9,77,000. Anyone else who has calculated?
41,20,000.
41,20,000. You are nearby, sir.
Sir, 35,80,000.
Okay. Okay. Anyone else? So we'll see what is the calculation.
Sir, if we take 41 as the age, it will be 38,50,000.
What the age you have taken?
His age actually 1/6/1983. His date of birth today he will be 40. So by the completion after 40 only we have to take the age factor,
Age
right?
factor of 40. Right. You are right. Let's see.
So for first question, 41,20,000, sir.
Okay. So 7,000 you have missed. You are nearby, but 7,000 as per the latest this increase, you have added 40,000. So you are somehow corrected. this 77,000. The 10% increase in general
I have
damage is
added
there.
70,000,
So
sir,
it should
instead
be.
of 77,000.
So that's why you got the.
Okay,
this
okay.
thing.
Sorry, sir.
So this screen is visible to everyone.
Yes, sir. Yes, sir.
Yes, sir.
Okay. So income was 20,000 per month. Right? Age I have calculated. Sorry. Age I have calculated 39 years 7 months. But you need to take the 39 years as last completed age is being calculated. Multiplier for, if you see the multiplier table, we go to back. If you see the multiplier table, it's a 36 to 40, it is a 15, multiplier of 15. So number of dependent is 4. So dependency will be 3 by 4, 1 minus 1 by 3. Personal expenses is 1/3.
Hello, sir. Dependency is 2 by 3, no, sir.
No, 4 to 6 is there, na? Total 4 dependent is there. See the dependency this thing. So 1/4 has to be deducted. 1/4 has to be deducted. I have deducted 1/4, but here the wrongly I have put in the 1/3. But the final this thing is 3/4 is the final one. If you minus 1/4 from the one, you will get the 3/4. So it's a typing error. Okay, understood everyone?
Yes, sir.
I have deducted the personal expenses as per dependent, considering the dependent of 4. So 1/4 has to be deducted, but mistakenly I have written here 1/3. So this 3/4 is the dependency. So future prospects applicable, he is having the permanent job and below the age of 40. So future prospects is for 50%. So if you see the formula, here I have put in the formula, monthly income into dependency into 12 for arriving at the annual income. Then the future prospects, then the multiplier. Here I have not deducted any income tax because the yearly income, if you see, 12 into 20 is 2,40,000. So income tax is not attractive. If someone is having the more than income tax is definitely attract as per the old or new regime, and it is being reduced. So for the just simple calculation, I have put in this data. So here 50% future prospects, 20,000 is monthly income, then the dependency 3/4. It is multiplied by 12 to arriving the annual income. Then the future prospects is being added, and then the final age multiplier, as per age, that is a 15. So you will get the 40,000, 40,50,000 as a compensation. So then the non-pecuniary damage, general damage is of 77,000. It is being added. So total claim compensation, if someone is having the age of 39 or up to the age of 40, just earning the 20,000 rupees. So that dependent and dependent, 4 dependent is here. He is eligible to get this 41,27,000 plus medical bill if any, and plus the interest from the date of
Sir,
filing the
excuse me,
application.
77,000 ka you
70,000.
how you have calculated 77,000?
Yeah. 70,000, 15,000 for funeral expenses, 15,000 for loss of estate, and loss of consortium. As per Parnashati, I have calculated loss of consortium only. I have taken 40,000. So total come to the 70,000. But the as per judgment, as the judgment came in the 18 Parnashati, so now it has completed the 3 years, not the 6 years. So if 6 years completed, it will again increase by 10%, and then the 84,000 will be calculated, 20% of the 70,000. So now recently, today I am calculating this compensation. So I have considered 10%, 110% of the 70,000. So it is 77,000. Is it clear? I have added 10% of 70,000.
Yes, sir.
So total claim compensation is 41,27,000. One most important thing I have told you, I have not written here. Interest is being calculated in claim under section 166 from the date of filing application, not from the date of accident. So it you should have this question arises from where the claim compensation interest is being calculated. It is from the date of filing the application to the claim tribunal by the tribunal or by the advocate. So now the solution for the another question, the driver having the age of 65 years died and having 4 dependent. There is no calculation for dependent. There is no other calculation. Calculation is very simple for the WC employee Act compensation. That is a 60,000. It is a fatal case, so you have taken the 50%. If it is a injured case, we should take the 60% and then the percentage of disablement as per the schedule. So 60,000 into 50%, and the lowest multiplier for the age of 65, it is 9.36. So total it is came to 7,94,880 plus medical bill FNE and plus the interest. Here the interest is being paid from the date of accident. That you should make it clear for claim compensation in WC forum. It is calculated interest from the date of accident because he is eligible to get the claim compensation on that day only when the accident occurred. Employer has to pay, as per law, employer is to pay the first claim compensation to the victim and then claim the compensation from the insurance company. But practically it is not being happen. We are only paying by under the this thing, Employee Compensation Act. Should I move ahead, sir?
Sir, what will be the rate of interest?
Sir, in WC forum, we are getting still the rate of interest as per the WC Act 12%. It is much higher than the other this thing, but for the MSCT cases under section 166, we are getting the variable rate of interest. It is there as per the bank rate plus 2%. So sometimes you are getting 7%, 7.5%, 8%, but WC form it is fixed 12% interest is being paid from the date of accident. For MSCT from the date of filing petition as per the this thing, how the judge is pronouncing the order and what is the thought process. 7 to 8% we are getting, 8.5% earlier we are getting, not more than that. Should I move ahead, sir? Question may come for the WC only. What is the interest rate? Because here there is no fix and we are still contesting and pleading to the tribunal. It should be as per bank rate. So now we will move ahead about the this Motor Vehicle Amendment Act 2019. There is so many provision has been changed. Take a minute. So this Gazette came on 9 August 2019. Central government has notified some section 50 to 57 and 93 of this Amendment Act that should come into effect from 1st April 2022. These all are the section which is related to the DL and all. So section 50, that the chapter 10, what is this section 50 of the amendment? If I am talking this section 50 is of the amended Act 2019. But what this section 50 of the amended Act is telling, we are still taking all the section of Motor Vehicle Act as per MV Act 1988. Some slightly changes there that I will let you know on the further course of this training lecture. So amended this section 50 is telling chapter 10 is principal act shall be omitted, section 140 to 144, that is concerning with liability without fault in certain cases. Popularly we are telling it's no fault liability. So entire section has been omitted. But as the implementation is still awaiting, we are getting this NFL award. So section 51 of the amendment is telling chapter 11 insurance of the motor vehicle against third party risk. So this third party risk is initially in 1939 only made compulsory, and yesterday also we see in the lecture that we should, before cancellation of a policy, we should ensure that the third party policy is there in force for that vehicle. Am I right, sir? So hello, anyone?
Yes, sir. Yes, sir.
Hello.
So
Sorry. Hello, sorry to disturb, sir. Hello.
Tell me, sir.
Sir, your WC calculation स्क्रीन पर अपीयर नहीं हुई, वो WC का जो कैलकुलेशन है ना क्लेम का,
हाँ, नीचे मैंने दिया था ना सर, उसी पे सॉल्यूशन
आया
2
नहीं,
जो
उसमें
था।
सॉल्यूशन 2 में आया नहीं, वो अपीयर नहीं हो रहा है।
अच्छा, आपको नहीं दिख पाया है सर, आप बाकी को दिख रहा है सॉल्यूशन?
But sir, we can able to see that, sir.
Yes, sir, you are able to.
There
Solution
might be,
2
sir. You may have connected with the mobile, sir.
Yes.
You have to tap the screen.
Okay.
Okay, so that might be the issue. Nothing is there, sir. 50% of the monthly wages multiplied by the relevant multiplier. I have taken the age as a 65 years of the driver. So we have multiplied by it by the lowest factor, that is 99.36. Because that the schedule of this WC, you need not to be remembered. You only need to remember the what is the highest one and factor and what is the lowest.
Correct.
Question may came from there.
The lowest is 99.36.
Right, sir.
And maximum?
I have written here, sir, 250, 228.54. Are you able to see, sir? Sorry. 228.54.
Okay, sir.
So I was here telling you about this third party mandatory, or it is a policy which is being cancelled. Entire policy is being cancelled. In the case of double insurance, you need to confirm whether the third party policy is there for that vehicle or not. So cancelling any policy by the insurer. So Chapter 51, Section 145(1) is telling this third party includes the government, the driver. Earlier, the driver word is not there, so driver is not able to make the claim compensation under Section 166. So this Motor Vehicle Act has been amended, and Section 145(1) in the definition of third party, it has been earlier also it was the government. Now it has been added with the driver. Driver is also a third party. And on implementation of this amendment act, driver may also file the claim compensation under Section 166, because the claim compensation under 166 is unlimited, whereas for WC claim it is a limited. We can say up to a certain limit it is a limited, because it is totally on the multiplier and the monthly income of the driver or the any person who is employed on the vehicle. Normally, we are seeing the claim filed by a cleaner or conductor or any other employee of owner of the vehicle under the MSCT forum only under Section 166, because the claim compensation is more than the WC forum. You have seen in example, there is one is having the 65 years old age, another is having the 40 years of age, another is having the 16,000 salary. Under MSCT, it is having only 20,000. But claim compensation is entirely I think say 6 to 7 times it is increased for this much of the variation. So this third party is also include any co-worker on a transport vehicle, driver, conductor, cleaner. Then the Section 146 necessitate the insurance against third party risk. I was talking about this third party risk only, which was made compulsory as per the Motor Vehicle Act 1939. If you see the inception of the Motor Vehicle Act, it made the third party policy compulsory. So also this Section 146 saying if a vehicle carrying the hazardous good, it should have the public liability policy, because if explosive or hazardous may get explode or may affect the public, this motor vehicle policy cannot cover all the liability. So it is there. It made mandatory for the vehicle carrying hazardous goods that it should have the public liability policy under Section 146. So you just keep in mind, if a vehicle carrying hazardous goods, which policy is compulsory? Which policy is mandatory? It's a public liability policy. Apart from the motor vehicle, apart from this TP policy or package policy. So section 147, how insurance policy is there? Who can issue this insurance policy? It is talking about the insurance policy. A policy of insurance must be a policy which is issued by a person who is an authorized insurer. So now this section 149, recently it has been, as per amendment, this has this new insertion of this act. Earlier we had all the defense under section 149. Popularly we are telling this insurance company does not having the defense under section 149 too, but you see as per this amendment, section 149, entire something else it is written. It is a DAR mechanism where the timeline is there, where the claim compensation can be paid quickly. The mechanism has been introduced by the Supreme Court, and it was practiced, or you can say on the pilot basis, it has been tested at Delhi or somewhere in Karnataka. One popular case is there where Bajaj has paid some 10 crore of rupees within 10 days or 4 days. I don't remember the actual amount, but it has been shown to the, it's a landmark to the other insurance company that you can also do. So what is the provision is there? Insurance company on receiving of the claim application or about the information about the accident, he should designate an officer to settle that third party claim. So within 30 days, that designated officer may make an offer of settlement before the tribunal. So this offer of settlement is offered by the designated officer before the tribunal to the claimant. If the offer is accepted by the claimant, the tribunal will record the consent of settlement. That is what is the consent, how much amount you are agreed and how much amount you have offered and the claimant has agreed. That the consent of settlement is recorded by the tribunal, and payment shall be made within 30 days on receipt of the order copy. This 30 days is everywhere. That is as per Motor Vehicle Act. Under section, I think 160, I will tell you the exact section. That is there. After receiving the award copy, judgment certified copy, how much time insurance company is permitted to satisfy that award? That is a 30 days. So if the claimant, either claimant will accept your offer, the offer given by the designated officer, or he reject the offer. So if a claimant rejects such offer, a date of hearing for normal proceeding will be fixed by the claim tribunal to contest the matter on merit. What is the fact of the case? If he is not accepting your offer, you are offering, maybe you are not offering the future prospects, maybe you are not considering the interest part. So we may reject your offer, and then the claim will be proceeded as a normal. So this is the insertion of section 149.
Sir, one question was there.
Tell me, sir.
So under this this section you are saying, so the appointment of advocate is not necessitated. It will be directly.
Here appointment of advocate is not necessary. Here one thing is also there. The DAR is filed by the police authority, also treated as a claim application. Claimant should not file the should not appoint the advocate to this thing. So to avoid the litigation and to get the settlement quicker, to enable the claimant to get the compensation on within I can say the 3 months. You can say clearly it is there within 3 months after occurring any accident, he may get the claim compensation under this section. Is it clear?
If at all we receive, yeah. So if at all advocate is appointed by the claimant, so even we cannot go with such kind of settlement.
Repeat your question, sir.
If an advocate, if we receive the summons, so the claimant has appointed an advocate. So if in that case also we will not be able to process, or we can go ahead with such kind of settlement.
he has appointed the advocate. That is his part. We can offer the, if I receive information about the accident under section 149, we will offer the this settlement amount. Whether he has appointed the advocate or not, that is not our concern.
Okay, okay, sir.
So,
Hello.
tell me, sir.
Sir, what is the full form of DAR?
Detailed accident report, sir.
Detailed accident report. Okay.
Yeah, yeah. Detailed accident report.
Okay.
I was talking about this 149 settlement by insurance company. DAR mechanism, detailed accident report. This report is being prepared by the police authority within 3 months. I have written somewhere on the further slide.
Newly introduced.
It is a newly introduced section, sir. Question may arise from this section. And this timeline may might be asked. The first timeline, when the insurance company, the designated officer, what timeline he has to make the offer of settlement. The another timeline is for the general listing. The 30 days is there as per the Motor Vehicle Act.
Okay.
To satisfy the award. That is applicable for every claim petition, every award.
Thank you.
Should I move ahead, sir?
Yes, yes.
So now all the defense which were available in the section 149(2), now it is known as per the amendment. It should be known as section 152. So still we are talking about the 149(2) only. While we are talking to someone, we say as per 149(2) we have this defense. So now it will be read as a section 152. Here the duty of insurer is to satisfy the award. Once you receive the judgment, you should satisfy the award against person injured in respect of third party risk. Another para is written, no sum shall be payable by an insurer. So what is the defense is coming under this? We are not liable to pay the compensation in the following circumstances. If there has been a breach of a specified condition of policy, being one of the following conditions. What are the terms and conditions? If there is a breach of policy terms and conditions, if a vehicle is used first, if the vehicle is used for hire and reward, we are not liable to pay. No sum shall be payable by an insurer. For organized racing, we are mentioning on the face of policy also all these points. Not allowed by the permit. Yesterday we are talking about limitation as to use. If a vehicle is designed to carry a passenger and it is carrying goods, if a vehicle is designed to carry the goods, if it is carrying the passenger, known as gratuitous passenger. So these all is a breach of policy terms and condition, and we are not liable to pay in that case. One driver clause is there, that is most important regarding the DL. This is newly introduced in this section 149(2), you can say, or you can say either 152. So driver clause, earlier also driver clause was there, where it has written a person who is entitled to drive the vehicle, and we are writing the driver clause on the face of policy, but still not writing the driver clause as per the amendment, because as per amendment it has included, after this completion of para, it has written that the driver driving a vehicle under the influence of alcohol or drugs as laid down in section 185. So I will tell you later what is the section 185 and when a person is not able to exercise proper control on the vehicle. If someone is smelling that he is under the influence of alcohol, not only that can prove that the vehicle driver is under the influence of alcohol. We'll see the letter, but this has been added, and yesterday sir was telling it should be on the other part also, OD part also. So we have a section, we have a defense, valid defense. Earlier it was not there, so this highlighted one is added, amended recently. Non-disclosure of any material facts. That it is our principle of the insurance, that is utmost good faith is there. So if non-disclosure of any material fact is there, our compensation we are not liable to pay. And this also highlighted the C, non-receipt of premium as required under section 64 BB, the insurance Act 1938. It is also telling earlier it was not there. In section 149(2), it was not there. It was recently amended. If an insurance company is not getting the consideration, there is no compliance of section 64 BB, we are not liable to pay any compensation. There might be a check dishonour case. There might be a only RTO has made us a party on the basis of claimant or proceeding. Tribunal has made us a party on the basis of RC information of the vehicle that the New India or some other insurance company has a policy. They have written the cover note number and validity. They may have written the policy number which is not there in our system. So that case is there, but now we are having a valid defense that if we have not received our consideration and we are able to prove before the tribunal, we are not liable to pay any compensation. Should I move ahead, sir?
Yes.
So section 157, yesterday there was this thing. This section 157 is only telling transfer of the certificate of insurance. So for OD part, as you know, aware about it should be transferred within 14 days, or in case of death of owner, legal hire should transfer the policy within 90 days. Any claim under OD part, if it is within 90 days, as told by Pratik sir yesterday, it is payable. But for this third party, what is about the third party? Yesterday, sir has clarified that the third party claim is payable because certificate of insurance shall be deemed to have been transferred in favor of the person to whom the motor vehicle is transferred with effect from the date of its transfer. So you will find the date of transfer on the RC information received from the RTO. From the date of that the transfer, that the third party part or third party policy is deemed to be transferred to the new owner. So whether new owner is the part of the proceeding, it should be as per RC information only. They are making the party of the proceeding. So new owner is the part of the proceeding, but policy is not in the name of the new owner. But third party should not get affected because third party compensation is it is a compensation. Some social view or some compensatory view is always there to satisfy this third party compensation. So someone is telling before court of law everything is payable. So somehow it is correct that before court of law everything is payable, but we are getting the recovery rights. We are getting this thing once we are going to pay. And once we are not able to prove our this thing, consideration of 64 VV, most of the case in the case of check dishonour, we are not having the original instrument. We have not intimated the concerned RTO. We have not intimated the insured. We have intimated, but we don't keep the postal receipt or the registered ID card. So these all are the documents is very much required by the claim handling office to contest the matter effectively. So many times I need to write the concern underwriting office, and from this panel, I humbly request all of the seniors who is heading the offices and all, that in case of check dishonour, you should have a proper line of communication with the insured, with the RTO. You should keep the postal receipt. If you don't get the registered ID card, that the postal receipt itself telling that if you have intimated the RTO, if you have intimated the insured, and you have the postal receipt, it is deemed to be served to them. Instead, you have not having the postal registered ID card. So that is required, and it should be before the date of accident. If accident occurred, then the underwriting officers or offices from where the policy has been issued, they have initiated to intimate the RTO and the insured. It is known as it may be claimed by the claimant or the claimant advocate. It's a afterthought. So after the accident, he has intimated. He has not followed we can say the SOP, standard operating procedure. So that is there. So section 157, I have moved away from the topic. Section 157 is there. That is third party portion. Section 2 of the portion policy. It is deemed to be transferred to the new owner. Deems transfer shall include transfer of rights and liability of the said certificate of insurance. So we will move further. Section 134C, duty of driver in case of accident. He has to give the following information to the insurer: policy details, the date, time, place of accident, particulars of person injured or killed. Our claim form is there, where you need to write everything. Name of driver and particulars of his driving license. So expression driver includes the owner of the vehicle. So you just go through the section where the duty of driver is there. Then the section 159, information to be given regarding accident. This is applicable for the police authority. Sometimes the police authority may not cooperate the insurance company. So in that case, we can write a letter to the police authority as per this section 159. Information is to be given by the concerned police officer. He shall prepare an accident information report and facilitate the settlement of claim within 3 months. Her timeline is there, within 3 months, and submit the same to the claim tribunal and such other agency. So we are considered, insurance company can be considered as such other agency. So sometimes RTO also refuse you to give the vehicle information, stating that this is a third party information we cannot give you. So I have insisted our investigator that you say there is a section of Motor Vehicle Act. Everything is there in the Motor Vehicle Act. We just need to implement. We just need to communicate. You will get the information. Due to furnish particular of vehicle involving in an accident, here the registering authority, that is RTO or officer in charge of a police station, shall, if so required by a person who alleges that he is entitled to claim compensation in respect of an accident arising out of the use of motor vehicle, of if so required by an insurer against whom a claim has been made in respect of any motor vehicle, furnished to that person or to that insurer as the case may be on the payment of dispatch fee. RTO is charging us around 100-200 rupees for the information. He has to provide us. So further section 161 is there. That is compensation in case of hit and run, that we have earlier also we have told it has been increased multiple times. We can say the 8 times in the case of this fatal rupees 2 lakh or such higher amount. This section is telling prescribed by the central government for grievous hurt a fixed sum of 50,000 rupees. For grievous hurt, again I am telling, there is a section in IPC, section 137, 337 and 338. You should remember section 338 for the grievous hurt. For making any claim compensation, that should be there. So this 161 is important. Again, 162 is more important. A scheme for golden hours. Yesterday or some other day also I have seen this is important one. Golden hours means the time period lasting 1 hour following a traumatic injury. So this 1 hour is very much important, and it can save someone's life, during which there is a highest likelihood of preventing death by providing prompt medical care. So that is there in the section 162. You need not to remember what is there in what is section 161, what is section 162. You should remember the content of that. Question may come for the content.
So I have one query, sir.
Yeah,
I have a
tell
query.
me.
Under 161, you said the amount has been revised from 25,000, 12,500 to 2 lakhs and 50,000.
Right,
Has it been implemented?
Sir,
we are still getting
on
awards
the
of 25,000 and 12,500.
Sir, this is under solution fund, sir. So this is court involvement is not there. They are the tribunal. There is a collectorate office, district collectorate office. They are maintaining. They are making the application to the offices. So this the implemented one is there, but whether there is a further we will show you the slide where the third party fund is there, it is to be maintained. So now all these things has to be implemented because interim application, that is section 140, that has been omitted. So from where he will get for this golden hour also there is a provision that the cashless treatment is required. From where the cashless treatment insurer or the government is going to be provided. So all there is a fund. We will say you the further. So implementation is still.
So, but the collector office in Chhattisgarh is not giving new awards, new orders.
New orders he is not giving. It might be possible, sir.
That's why whether it is implemented or not.
That is not implemented, sir. Still, because there is a, if you see now, government shall make a scheme for cashless. This golden hour is only telling. Here 164B, motor vehicle accident fund. This fund has to be maintained. Central government shall constitute a fund to be called the motor vehicle accident fund. Fund shall be audited by CAG, and also this fund has not been still constituted by the government. So this is the golden hour scheme. This is the interim application, that the solution fund. Everything is there in the motor vehicle accident fund. From here it should be go. So still there is an implementation. You can say government may plan as per the amendment, but still it is not there. Should I move ahead, sir?
Yes, sir.
Yes, sir.
Okay. So the insurer shall provide for the treatment of road accident victim, including during the golden hours. That the cashless treatment it is telling. The central government shall make the scheme for the cashless treatment of victims of the accident during the golden hours. So one more word is there, Good Samaritan. We will cover that also. That is required. As a human, as a sincere citizen or good citizen, we can say we are used to help out the victim. But earlier it is there is a classes that the individual may be implemented for the questioning and the evidence and everything. So now it has been simplified. We will see you later. So section 164 now, earlier it was known as 163 alpha. Earlier also I have told you the payment of compensation in case of death and the grievous hurt or the grievous hurt etc. Compensation for death is 5 lakh and for grievous hurt 2,50,000. Claimant is not required to establish the fault or negligence of the owner of the vehicle or the vehicle concerned or any other person. Clearly here it is written, who is a poor claimant cannot afford the court proceeding. So we will not move further to establish. He may not be able to get the eyewitness or the evidence to establish who is on fault. So for them, it has came into the amendment of 1994. I have told there the 163A and 163B was implemented on the structural formula basis. In 2018, there is an amendment for 163 alpha, where the 25,000 provision for the normal injury also there. As per amendment under section 164, now it has been revised where the negligence is not required to prove. So if our IV is standing on a signal, there is a red signal, car is standing there. One motorcyclist went from behind and he hit the our IV, that the private car, and he got himself injured, maybe fatality is there. He can also claim under section 163A, and that is payable. Am I clear? Negligence is not required to be proved. Should I move ahead, sir?
Yes, sir.
Yes, sir.
So 164 alpha is there, a scheme for interim relief for the claimant. The central government may make a scheme for the provision of the interim relief to the claimant paying for compensation, because omission of the section 140 will attract this section, that the 164 alpha, because interim compensation need to be paid to the victim at the earliest to facilitate treatment and any other requirement. I have told you a little bit about this 164B, Motor Vehicle Accident Fund, uh, utilized for section 161 and 162. I have written 161, if you are remembering, it is hit and run cases, as I have told, and 162, it is for golden hour scheme. No? Yes. So this motor vehicle accident fund, question may arise, which fund or what is section 164B. So it's a motor vehicle accident fund that need to be constituted as per the amendment, and the whatever the compensation under section 161 and 162 is required to be paid, that is to be paid under this motor vehicle accident fund, and this fund shall be audited by CAD. That is there. Clear, sir?
Yes, sir.
Yes, sir.
Now the chapter 12, section 165. Nothing is there. It's a claim tribunal. Whatever section I have written, it is having some meaning, and question may arise from this only. So you should not read the other sections and all the question, 5-6 question, whatever is there. It is not as per the section wise. Maybe this section, important section for permit, fitness, registration, DL, it may come. What are the section in that? Which section it is covering? But other section you need to just study what is there in that section, not the section. So 165 is the claim tribunal. It is telling about the constitution of claim and everything. Then the section 166 is there, application. I have told you this section 166. We are discussing so many about section 166. It is a application for compensation under fault liability. Issues to be proved under section 166. What are the issues required to be proved? That the factum of the accident, factum of the insurance, we have taken the consideration, and 64 BB has complied. Then the age of the victim, what are the age, documentary evidence is required. Then the most important is factum of negligence. Negligence is to be proved in the, as it is a fault liability. If we are 20% only eligible, insurance company is only 20% eligible, entire claim compensation is reduced by 20%, 80% on the part of others. He may be the victim itself or the some other vehicle. We'll tell you about the composite and contributory negligence later. So income is also required to be proved. Documentary evidence, evidence of the employer is required to be given, and the factum of dependency, who is actual dependent on the victim, you can say. So this is required to be proved. So jurisdiction where a claim application can be filed, where the claimant normally resides or works, we can say, where accident took place, and where respondent resides. So as this para C have the broader sense of this thing, as an insurance company we are having not only all over the country, on other global also we are having the exposure. So if the respondent officer is there, he can file the claim against New India or maybe against any where he may feel. So right of claim compensation for injury upon the death of injury. Yes, one more important thing is there. Earlier, it is there that the death, if it is arising out of the injury, if someone got injured on 1st of this month and he may died on the 20th of this month. So there is a relation between the under treatment. Is there any relation between the death arising out of that injury of that accident? If it is proved, then only claim is payable. But this amendment Under section 166 recently it has been amended. Right of claim compensation for injury upon the death of injured shall survive to the legal representative, irrespective of cause death is related to such injury or not. Any doubts, sir? Because it has the broader sense. We are telling about the proximate cause. Death should arising out of the accidental injury. But here it is telling legal representative is entitled to get the compensation if it is arising death out of an injury, whether death is related to such injury or not. Clear, sir? Should I move ahead? Hello.
Yes, sir.
Should I move ahead? Or
Yes, sir.
any
Yes, sir.
clarity is needed on this point? You may ask the later. We need to close. So, report under section 159 shall also be treated as application for claim compensation. So, I told you about this section 159 where the police authority is required to make the investigation and to file the report within 3 months. We'll cover it later. So, under section 166(3), this is the good initiative as per the amendment. Some initiative may in future will be useful for the insurance company, that the no application for compensation shall be entertained unless it is made within 6 months of the occurrence of the accident. If question arises as per the new amendment, what is the timeline to be file a claim compensation? It is a 6 months from the date of accident. Still it is not implemented. We are getting the earlier one only. So 167 is telling option regarding the claim for compensation. When claim arises under this act, under WC, the person entitled to claim compensation may claim compensation only under either of these acts and not under both of these. If a claim is arising under WC forum also and under Motor Vehicle Act, this is the section 166 is there. So if claim is arising there under WC, so he may file. He is allowed to file either of the forum, but not under the both forum, not under the both MSCT and WC forum. Normally, it is for the employer, driver, cleaner. Uh, Now the driver can also file. Someone has switched on the mic. Namita ji, please switch out the mic. Okay. So that is there. Option is there. He can file either of this forum, but not under the both forum. Section 168, award of the claim tribunal. I was telling about this timeline. Tribunal should provide us the judgment or the certified copy within the 15 days. That is practically not possible, and that is practically not happening. We are not still receiving any claim awarded within 15 days copy of the court order. So the timeline is there as per the section 168, and that timeline is there for the us for insurer. It is within 30 days. It is to be satisfied award to be satisfied within 30 days from the date of award or received by the insurance company or any other respondent. So section 170 is there. Impleading insurer in question may come from here. This 30 days may sometimes question is there. How much timeline is required and how much time is required for the insurance company to satisfy and award. So it is a 30 days, not 1 month. There is a difference in 1 month and 30 days. So impleading insurer in certain cases, important in this claim application. Our application under section 170 is most important for filing an appeal. So what is section 170? That is right to contest the claim on all or any of the ground contained in section 152. Now we have the defense under section 152. So we can contest the claim petition before the tribunal under section 170. This is giving us the right. So why this right is required? There might be a collusion between the applicant and the insured, or insured has failed to contest the claim. Most of the time, insured is not approaching or not uh, contesting the matter before the tribunal. Insurance company है देख लेगा वो अपना सब कुछ. So that is the tendency of the insured. So they are not appearing for the contesting the claim. So we are required to file the section claim application under section 170 to get the right to contest the claim application. If insured is there, we are limited with our this thing proceeding. So tribunal may direct the insurer who may be liable in respect of such claim shall be implicated as a party of the proceeding. So insurer who is liable to pay the claim compensation, normally claimant or claimant advocate is making us the party at the first instance. So he come to know insurance company is there, he or she are making us the party. So that is as per section 170. (173) is telling us about the appeal. Appeal should be filed within 90 days from the date of receipt of award. There might be a delay. Pronouncement and the receipt of date might be it is having 1 month, 2 months. The day you receive the award, from there, this timeline is started practically. But if question is there, any person aggrieved by an award of a claim tribunal may, within 90 days from the date of award, prefer an appeal to the High Court. If tribunal has provided you the copy of award within 15 days as per section 168, now you are bound to file appeal within 90 days because he has provided you the copy as per timeline what is there in the motor vehicle. So a statutory deposit is question may arises from here. What is the statutory deposit? Minimum 25,000 or the 50% of the awarded amount, whichever is less. Earlier, if the amount in dispute is more than 10,000 as per the earlier Act 1988, you can file the appeal, but amendment is there, no appeal for less than 1 lakh of the disputed amount is required to be filed. There is a little bit clarification on this point. He is telling about the disputed amount, not the awarded amount. Sometimes we are filing the appeal, there is no such breach of the policy terms and condition, but the awarded amount is much higher or higher than our calculation. So there is an error in considering of the monthly income. So we are going to file appeal, award to be reduced. Normally it is not happening. So in that case, if the amount in dispute, as per your calculation, as per the court award, if the disputed amount is within 1 lakh, the appeal is not required to be filed. Claim can appeal is not entertained by the High Court or the other courts. So High Court may entertain the appeal after the expiry of this the 90 days. There is a condonation of delay option is there. If it is satisfied that the applicant was prevented by sufficient cause for preferring the appeal in time. So what is the prevention in our case? We are not getting the certified copy of the award on time. So unless until we got the certified copy of award, we are not able to move ahead, and we have prevented to file the appeal. So in that case, condonation of delay is there. So section 170 application is mandatory to file the appeal. So appeal, this section 170 is there. Application under section 170 is required. We are filing the contest the matter. Earlier I have told you, contest the matter to get the rights of insured. To get the right of insured, whatever the right of insured to contest a matter, we are also getting the right of insured to contest or to contest that matter. So this section 170 application is only required in the case of insured. If insured is not there, in the case of check disowner, there is no insured, he is not our insured. So this claim application is not required. In the case of check disowner, forged policy, not insured only made us the party on the basis of RC, and other cases, orphan cases you can say. Normally we are registering such cases as orphan cases. So in that cases, this claim application, this section application under section 170 is to whom rights we are going to contest the claim. There is no insured, so there is no the applicability of the uh, rights of the insured. So this is only applicable when insured is there. So one more aspect is there important. Ground of appeal should be pleaded before the lower court or tribunal. If you are telling that the DL was not valid, but you have not concluded that the DL was not valid, and you have not included that thing before the lower court, and after the pronouncement of the award you come to know about the DL was not valid, and now you are telling that DL was not valid, so higher court is not going to entertain. So this pleading before the lower court is very much required. Clear?
Yes, sir.
Clear, everyone?
Sir, yes, sir.
Yeah. Moving ahead, a broader aspect, there is a license, there is a driving license, there is a various changes in this driving license.
Excuse me, sir.
Tell me.
Sir, I need to like the time period of. Hello, can you hear
Tell
me?
me, man. Yeah,
Okay.
yeah, I am hearing.
The time period is district to state level and
That
state
is
to
there. That is
national.
there. That is there on the further slide. I am going to cover it.
Okay, because it's a very confusing question, and I.
See, for motor vehicle accident, it is 90 days. For other aspects, I am going to tell you.
Okay.
That is there on the slide. You will go through the slide. It is very much clear there. Two provision is there: 30 days and 45 days. If district court, district forum to the state forum, it is 30 days. If it is from a state forum to national forum, it is 45 days. 30 days, 45 days, here 90 days.
But somewhere written is like district to state 45 or state to national 30 or national to high 30.
Let me check. Let me check. That is there on the slide.
Like much clarity on this because the limit
we
is.
will get it. On the further slide, it is there. So driving license question may arise from here. So be careful while doing this question, because earlier provision is something else. Now it has been revised. So up to the age of 30 years, if someone is having the age of 30 years, to get this kind of license, what are the license? Motorcycle with gear, adapted vehicle, it is for physically disabled person. Then the LMB, which is having the definition itself is telling LMB, gross vehicle weight up to 7,500 kg. So these all three kinds of license we are issuing RTO issuing the license for age up to 30 years. You are get the license valid up to age of 40 years as per latest system. So if the age someone is after 30 years and up to the 50 years, because of that only I have written the age in between. If it is greater than 30 years and less than 50 years, he will get the validity of license for 10 years. If someone ages 50 to 55 years, he will get the license up to the age of 60 years. But if the age is more than 55 years, he will get the license for another 5 years. Suppose, so there is two provision to get the 5 years and 10 years validity. One is for 30 to 50 and another is above 55 years. But another is up to the 40 years and up to the 60 years, he will get the one is the up to 30 years. If the someone is having the age of 30 years, he will get 40 years license validity up to the age of 40 years. And if someone is having the age between 50 to 55, he will get the license valid up to the age of 60 years. Is it clear? Someone
Sir,
is having
and
the
whose age is
of
45, whose age is 45, Then how much period? Means up to 50. Means he will
55
get
years.
license for
55 years. 55 years. There is clear, na 30 to 50 years. He will get the extension for 10 years.
10 years. Means 45 means he up to the age of his 55.
Up to the age of 55.
Yes, sir.
So if someone is having the age of 54 years, till when he will going to get the license validity, ma'am?
60 years.
60
3
years.
years. 60 years.
If someone is having the age of 56 years, till when he is going to get the license valid?
5 years.
56.
5
5
years.
years, that is up to the age of
61
2 years
years.
from now.
61
You can
years.
say, yeah. Okay. So that is very much clear from here. If someone is having the age up to the age of 30 years, he will get the validity of license till 40 years. First. Second one, age between 30 to 50. If someone is having the 49 years of age, he will get the 10 years extension, that is 59 years. Then if age is between 50 to 55, he will get up to 60. If age crosses after 55, he will get the 5 years validity. Clear, sir? Minimum qualification is there here. Minimum age should be the 18 years. Should I move ahead?
Yes, sir.
Yes, sir.
Transport vehicle validity is given for 5 years. Minimum age is required 20 years. 1 year after issuance of light motor vehicle. This is the qualification required. If someone is having light LMB license, he should wait for another year to get the transport license. Earlier, the provision was 3 years. Validity of the transport license was 3 years. So now it has been revised for 5 years. Minimum age is 20 years. 1 years, 1 years of LMB after issuance of 1 years of LMB. After issuance of learner license, of how many month or days you are eligible to get the license? I have a question.
6 months.
6 months.
6
6
months.
months is the validity of learner license, but you are eligible to get the license after how
3
many?
months. 3 months.
30 days.
30 days.
40
Right.
days.
1 month is there. After issuance of the learner license of 1 month, you are eligible to get the license. Clear? So that the question is there. Why I have asked
Pardon,
you?
sir. We are not getting your point that time.
I have told you about the learner license. There is a question here for transport license that after issuance of the LMB, 1 year of issuance of the LMB, you are eligible to get the transport license. Like that, in the learner license case, after getting the 1 month of the issuance of learner license, only you are eligible to get the license, any kind of license, motor vehicle, motorcycle, or LMB. Clear? Because initially you will issued with the motorcycle and LMB only, if it is not the case of adapted. Then only issuance of the 1 year of LMB, you are eligible to get the transport. Am I clear?
Yes, sir.
Yes, sir. I have just mixed
Yes,
up
sir.
it
Yes,
with
sir.
the learner license. Now the road roller validity is 3 years. Earlier it was, I think, 1 year. So it has also increased. Minimum validity is 20 years. Medical required for operating the road roller. So endorsement to the carry hazardous goods of the hazardous nature. It is earlier it was 1 year. Now it has also 3 years. And renewal thereof as condition of the central government may prescribe. So how the renewal is going to be? It is still required to be prescribed. So what is the requirement to get the hazardous endorsement on a DL? Medical, transport license, English, and 1 language from the Schedule 7. It is required to get a hazardous endorsement on a transport license. Clear? So Hello. What is expired license? Am I audible to everyone?
Yes, sir.
Yes, sir.
If the application for renewal of the license is made either 1 year prior of the date of expiry or within 1 year after the date of expiry, renewal of license with effect from the date of its renewal. It is telling if your license is expiring on the 31st December 2023. So if you are applying for the renewal on the 1st of the Jan 23 or the 31st of the December of the 24, your validity as per the applicability of the previous table will be renewed from the date of expiry of the current license. If the validity of license has lapsed for more than 1 year, the driver shall have to go undergo refresher course. That is there as per the latest provision. Earlier, the expired license is only for the 1 month. Validity of license is up to given validity up to 1 month. Claim is being paid if the accident occur within the 1 month after the expiry of license. So the extension is now moved on the broader picture. So it is prior to 1 years or after 1 years you can apply for the renewal of license, and your license will be renewed from the date of expiry of the current license only. So somehow it will reduce the dispute, our litigation also, because so many times we are getting the litigation increase on the issue of license only. License has expired. Clear? Validity of license after expiry is
Sir,
1 year. If question
one
arises.
question, sir. One question.
Tell me,
sir.
sir.
That a refresher course undergoes how many days?
Refresher course is like that if it is a hazardous goods, say 1 day training is required. If it is LMB, RTO may ask you to give the test if you have not driven the vehicle for 1 year. If a transport vehicle, any kind of vehicle, he may ask for you to give the test. That is the refresher. Or may ask the question related to the motor vehicle, this is the sign and all if it is required. Any kind of refresher is required. That is not mentioned anywhere, and it's a man presumption. It is a refresher course is like that one. Should I move ahead, sir?
Yes.
Yes, sir.
One question.
So, yeah, tell me, sir.
Suppose my driving license has expired.
Right.
And after 3 months, I have not applied for a fresh license.
Right.
After 3 months, there is an accident.
Right, sir.
I have not applied for a DL. So,
Right.
would the insurance company will be able to take a defense based on that, or it is not?
No,
defense is not
no,
valid?
no, sir. Defense is not applicable as the license is valid a further 1 year of this thing. As per the latest amendment, it is clearly told expiry of the license will occur after the 1 year's expiry of the 1 years of the license. Clear, sir?
1 year is
practice may not be followed right now because the implementation is still there, sir. Still we
Excuse me, sir.
the license after 4 months, 6 months, and you can get it renewed from the date of last expiry. So where there is a question to get this claim is to be reported, or insurance company may take the defense because your renewal from the date of expiry only. You apply for after accident, you will get the renewed from the date of expiry. Yeah, tell me.
Sir, one thing. After accident, the driving license has been seized. How you will apply for renewal?
you give the seized this thing to the RTO, na? There is an accident. We met with the accident. My license has been seized, and this is the unless until your license is cancelled or revoked for some other reason. That case may be the different. It is a merit of the case.
Sir,
Yeah,
1
tell
year
me.
like is the grace period. Earlier is 1 month like that.
1 month is there. That has been increased.
Like 1 year is the grace period.
Right, ma'am.
Like
1 year
in
is
the
the grace period right now. License will be renewed from the date of
sir,
last expiry of the.
my question is कि 1 year is the grace period in TP cases. If the license is expired and the accident like after 6 months, 8 months, then the claim is payable. 1 year is the grace period here. Like earlier
1 year
it was a 1 month.
Earlier it was 1 month for grace period. Now it has been renewed for 1 year. Clearly, it is telling your license will be renewed from the date of expiry. So if you apply on 31st December 2024 in the case of last this thing, so you will get your license renewed from the 31st December 23. If an accident occurred from the 31st December to 23 to 24, you will get your license renewed. There is no case of claim liquidation and all.
Or in the OD claim, I think claim is not payable if the license is expired.
License is expired at the time of accident. Clear? Now he has renewed the license from the date of last expiry, where the case license is not valid on the date of accident. You tell me. I have my license has expired on 31st December 23, and on 1st June I have renewed my license from the date of 31st December 23. So on the date of accident 15 March 24, whether my license is valid or not.
It's okay, sir. It's
Excuse
valid.
me, sir.
Yeah, tell
I
me, sir.
understand the license will be valid, but insurance company will still have a right to ask the insured to produce the valid
Suppose
driving license
I'm not.
after renewal, isn't it?
100%.
Definitely. I mean, unless and until the person makes an application, even after accident within the 1 year of the expiry of the license,
If he is not
but
renewing the
insurance
policy,
company has the right still to ask the insured that you renew the license with
yeah,
effect from the date of expiry.
renewal of license is
Yes.
very much required.
So,
That is there.
at the baseline, at any point of time, we are following our base rule that at the time of accident, you should have or you should possess the valid driving license, valid and effective.
That is my interpretation. That
That's it.
I will renew my policy, or someone who is the
So, unless and
driver.
until the person produces the new license after the expiry, we are not supposed to give the claim.
Oh, 1 year.
After the claim that I will apply for the renewal
Yes,
of the
ma'am.
license.
Yes, ma'am.
Right.
You can
And then
apply
claim
for
will
the
be
license.
payable.
Claim will be payable only after the person gets the new license with effective from its expiry date, isn't it?
No. We won't keep the body claim after 1 year. Then.
Madam, Devanshi madam, if in OD claims, unless he has to produce that he has applied for driving license, then only claim will be payable. Otherwise not. OD claim, huh?
Yeah.
Okay.
He will apply and he will get it renewed from the date of last expiry.
After the accident
Person has
also,
to
he
show
will
the
apply.
proof that he
Person
has
has to show the
applied
proof.
for
Exactly.
driving license.
Unless the person shows the proof, we are not liable to pay anything.
Okay. Should I move ahead now?
Yes,
Yes,
sir.
sir.
On license, there is this thing. Expired license I have covered. Applicable for all type of license. The above provision is applicable for all type of license except learner license. This para I have mentioned that the medium goods vehicle, medium passenger vehicle, and heavy goods vehicle, heavy passenger vehicle have been replaced by single entry, that is a transport vehicle. SMB, LMB has been replaced with the single entry, that is transport vehicle. And you see on the face of the DL extract, DL information, that the in class of vehicle it is only written as TRANS, that is trans. It is class of vehicle he is eligible to drive, that is a transport vehicle. Clear? Amendment has been there in the 1994 Motor Vehicle Act, in the Motor Vehicle Act of 1988, which was effected from 14/11/1994. So that is there. If a transport vehicle is there, if someone is having an endorsement of trans in the class of vehicle, so he is authorized to drive medium goods vehicle, heavy goods vehicle, medium passenger vehicle, and heavy passenger vehicle. LMB non-transport can LMB transport vehicle as per the latest Ministry of Road Transport and Highway notification dated 16 April 2018. It is arising out of a judgment, that is a apex court judgment, that is Mukund Devgan versus Oriental Insurance. So now Ministry of Road Transport and Highway has notified this. Everyone is aware of this fact that the LMB non-transport can also drive the LMB transport vehicle. So section 25 alpha, it is an important section because it is telling about the National Registry of DL. What is National Registry of DL? As per the latest amendment, the central government shall maintain a National Register of DL. All the state registry of DL shall be subsumed under the caption register by the date of notified by the central government. So still we have a different state register of the DL, not the National Register of DL. We are having the DL starting with GA, MH. Other state is having that the state registry of driving license. So now the section 25 alpha is there, which is telling about the National Register of driving license. So in future we can say the in single DL number one is that is applicable for entire country, that the National Register of DL driving license. We are over with the driving license. Yeah, tell me.
Excuse me, sir. So regarding the expired license, I have one question regarding the CPA claim.
Right.
If the person has the expired license and then dies in the road accident, then in that case, what would be the course of action? Because if he would have been alive, then he would have applied for the license and would have got some PTD or some claim. But now since he died, and now the claim arises of CPA, the license is expired. Shall we straightforward reject the claim?
Sir,
even if it is within the 1 year of the expiry of the license?
It is only I think applicable for OD part, because the practice is being followed that the license is valid as on date of accident. But for the other claim, CPM, I don't much aware about that. But for the legal claim, it is valid up to 1 year. We cannot dispute this thing. The claimant, we can also dispute, but the tribunal may award because he will consider the validity of license up to 1 year.
Yeah, means the court will definitely say that any
court will definitely consider the validity of DL.
But being insurance company, can we straightforward reject the claim, or shall we take the plea of this expired license?
No, we should take the legal opinion of any advocate before rejecting the claim.
Okay.
Sir, one question.
Because tell me.
LMV non-transport. LMV non-transport, LMV transport. Can drive LMV transport. LMV transport up to which
7,500.
Okay, up to which passengers?
LMV transport include both the transport and this passenger and the goods carrying vehicle. Up to the, I will tell you the definition of LMV. There is a definition of LMV. It will clear you.
Right.
Jadhav sir, we will take the little bit 15-20 minutes more. Is it okay?
Hello.
Hello.
Sir, regarding
we are taking 20 to 25 minutes more because some slide is still there. So it
no
is
problem.
Okay
no, it's okay with the participants. Are you okay?
Yes, sir.
sir.
Okay, sir.
Okay, sir, you can continue, sir.
Okay.
No problem.
Okay.
No problem, sir.
So as earlier,
Sir, one
I
question
have,
was there.
yeah, tell me,
Sir,
sir.
one question. Sir, just one of the participants said that if the driving license expires and if there is a claim. So, but sir, as per the MB Act, even if the license is expired, it is deemed to be continued till the next 1 month, na sir?
Now it has been amended. Now till 1 year it has been amended. Till 1 year it will be treated as a valid. It can be renewed from the date of last expiry. That is the main point of discussion. Earlier it was 30 days only. Now it has been amended up to 1 year. 1 year earlier also he can apply. 1 year later he can apply, and it will be treated as valid for some all other cases before the court of law. Adapted vehicle definition. Adapted vehicle, earlier it was known as invalid carriage, means you all be aware of this fact. I am just go through. Means a motor vehicle either especially designed and constructed for use of persons suffering from any physical defect or disability and used solely by or for such person. Normal person cannot use such vehicle. So that is the adapted vehicle. We are seeing that the vehicle is modified, but we can still use that vehicle. That is not the adapted vehicle. It should be solely used by the disabled person. So articulated vehicle, everybody is aware, a motor vehicle to which a semi-trailer is attached. Yesterday also maxi cab, motor car, all were discussed in the class. If a sitting capacity is more than 6 up to 12, excluding driver, there is more important, excluding driver, it is a maxi cab. Then motor cab, sitting capacity not more than 6, excluding driver. So motor car or motor vehicle other than the transport vehicle. If you see the face of this thing, RC extract, it is written as private car, PVT, CR. So light motor vehicle, there is a clear-cut definition where a transport vehicle or omnibus whose gross vehicle weight is less than 7,500 kg. For motor car, tractor, road roller, unladen weight is therefore less than 7,500 kg. Then only it will be treated as light motor vehicle. One is the unladen weight, another is the gross vehicle weight. So what is the gross vehicle weight? So gross vehicle weight is unladen weight plus the capacity. So if it is a motor car, if it is a tractor, if it is a road roller, you should go by the unladen weight. Somewhere it is written as the laden weight. Laden weight is also as a gross vehicle weight. It is a unladen weight plus the capacity. Clear? So absolute liability where the insurance company do not have any defense under section 152, or we can say there is no breach of policy terms and condition as per Motor Vehicle Act. There is a absolute liability up to the part of our negligence under section 166. If claim is there, two vehicle is involved. In the case of composite negligence, we'll discuss. So if contributory is 40-60%, our vehicle is 40% negligent, and the other vehicle is 60%. So up to 40%, we have the absolute liability. We can very much pay the 40% of the claim amount as a settlement or to the court also. So what is the composite negligence? Negligence on the part of two or more person or vehicle. If two vehicle involved in an accident or more than two vehicle, and if third person, those who are not driving this two vehicle, is injured, there is a case of negligence, a composite negligence. Clear? Negligence is not only on the part of single vehicle, it is a part of more than two or two vehicle, that is a composite negligence. I have written in the case of composite negligence also, absolute liability up to the negligence percent of insured vehicle is the absolute liability. So contributory negligence, when a person suffer injury partially due to his own negligence, there is a contribution in the accident of that person. Then the negligence on the part of injured or the part of victim which contribute to the accident is referred as contributory negligence. So I will tell you clear example how the composite negligence and the contributory negligence takes part. Uh, there is a motorcyclist who is driving and overtaking a vehicle from the right of our insured vehicle. There is another truck who is moving beside our insured vehicle so that the motorcyclist get into between. So he was hidden by the truck who is beside our insured vehicle, and then he fall towards our insured vehicle and got under the wheel of the insured vehicle and he died. So there is a case of composite negligence that the first who has hidden the motorcycle, that the beside truck, and then he came into the wheel of the our insured vehicle. So that is a case of composite negligence. There is a two vehicle involved. Contributory negligence, he was driving the vehicle rashly. The motorcyclist who was driving the vehicle rashly, suppose 20% he was negligent, not wearing helmet and any other cases. So he was uh, made himself injured up to 20% because of his own negligence. That is a contributory negligence. So uh, vicarious liability now, master holds for the servant negligence. In our case, our owner of the vehicle holds for the act or negligence of the driver. That is a vicarious liability. Tortfeasor, person who is responsible for the negligence. These are the words you will see in the judgment and everywhere. Tortfeasor is a person who is responsible for the negligence. Res is for liquidator. Things speaks for itself. Inquest Panchnama is there in the case of death. Ghatna Asthal Panchnama is also there, place Panchnama. So that is there. कैसे accident हुआ, that is there, that the things speaks for itself. Then as per one this thing, MC Mehta versus Union of India 2000 case is there, that the educational bus is not same as a commercial bus. That is there. Some important section. This section you need to remember. That is a section 3 is necessity of driving license. Section 4 age limit for holding a driving license. As I have earlier told, 18 years, 20 years. So section 181 is what? We are seeing a section framed on the chart sheet that 3/181, 4/181. So section 181 is telling driving vehicle in contravention of section 3 or 4. Whoever drive a motor vehicle in contravention of section 3 or 4, he will punishable with an imprisonment up to 3 months or a fine up to 5,000 or the both. So section 8, grant of learner license. Section 9, grant of DL. Here I have written validity of the learner license is 6 months and the can apply for DL after 1 month. Section 25 alpha, I have earlier this thing told National Register of Driving License, it is repeated one. Section 39 is for the necessity of registration. Before bringing any vehicle to the public place, vehicle is to be validly registered. That is there in the section 39. So section 43, temporary registration, that is only valid for 1 month. Section 56 is for fitness. Section 66 is for the permit. So you should remember what are in the case of transport vehicle, there is a 5 thing. One is a DL, that is there in the section 3 or 4. In section 181, that is a contravention. And the section 39 is a necessity of the registration. Then come to the section 56, that is a certificate of fitness. All the transport vehicle not deemed to have validly registered if not having a fitness certificate. Validity of the fitness is very much required to make the vehicle validly registered. If the fitness is expired, that vehicle is deemed to be not validly registered and cannot be used in public place. So latest amendment is there. If a vehicle is up to the 8 years, then fitness will renewed for 2 years. Then after 1 year. Clear? Here I have written the age of the vehicle. If the age of vehicle is up to 8 years, you will get the fitness validity up to 2 years. Earlier, the new vehicle only having the validity of the fitness up to 2 years. Now it has been amended up to the age of 8 years. You will get the validity of fitness for 2 years. Then subsequent years, you will get the validity of fitness for 1 year. So necessity of permit, that is section 6. So you should remember section 3, section 180, section 39, section 56, or now the section 66, that is the necessity of permit. These sections may ask by the examiner, because these are the important sections relevant to the actual we are facing day to day. We are working on this document. So no owner of a motor vehicle shall use or permit the use of vehicle as a transport vehicle. So in the case of transport only, fitness and permit is required in any public place unless authorized by RTO or prescribed authority for the use of vehicle in that place in a manner that vehicle is being used. So here, breach of you can say the geographical area or breach of route is also there in the permit, and the breach of use of the vehicle. So if some vehicle is carrying the goods which is outside the uh, trailer or container of the vehicle, that is not permissible, and the vehicle is not meant to use hanging or keeping the goods outside. Sometimes you find that the someone is loading the this iron rods and keeping the rods outside. So that vehicle is not meant to carry. That the open trailer is required to carry that the iron rods or any kind of such thing. So that is a violation of permit. So above provision is not applied to what you should go through these slides, because so many point is there. One important point is there: any goods vehicle whose gross vehicle weight does not exceed 3,000 kg, any goods vehicle whose GVW is less than 3,000, it is not required the permit. So if a vehicle owned by central or government, state government or local authority, that is a water conserving, road cleansing purpose, these vehicles are not required. Fire brigade, ambulance, these are not required for permit. Solely for conveyance of purposes, use towing for disabled vehicle. Towing vehicle is also not required any this permit. Any transport vehicle diverted due to the natural calamity. This is the case of route violation. So if there is a natural calamity, there is a flood or there is a landslide, so route is diverted to cover. We are having a permit authorized to play the vehicle in the state of Maharashtra only, but nearby Belgaum, that the route has been diverted to Karnataka. So if vehicle has to go through the Karnataka, in that case, permit is not required to cover the state Karnataka. Is it clear? So section 129 is bearing of protective headgear. It is applicable to two-wheeler. Every person above the age of 4 years required to bear the protective headgear. There is exception for the sick person who is sick, who is wearing a turban. If he is not wearing a turban, he is also required to wear a headgear. So below 4 years of the age, uh, any kids who is sitting on the motorcycle, he is required to uh, attach with a safety harness with the riders. So these are there in the section 129. Now the section 134 is an important section, that is duty of driver in case of accident. I think covered this section 134 earlier also, that he should inform when any person injured or any property of third party is damaged as a result of accident, the driver of the vehicle or other person in charge of the vehicle take the injured person to the nearest hospital, will inform about the incident to the nearest police station within 24 hours. Will inform, yes sir, will inform the insurer about the incident mentioning insurance policy. Yes, this is the important section, 185 we are telling about. So here one more word is there, good Samaritan, that is there in section 134 alpha. A person who is good faith, voluntarily and without expectation of any reward or compensation render emergency medical or non-medical care or assistance at the scene of any accident to the victim of transport or transport such victim to the hospital. So that is a good Samaritan, and he is there is a further amendment, some notification has come where the 5,000 rupees is there for here written that the without expectation of any reward, but earlier also I have covered in last hour this lecture that the good Samaritan who is assisting the injured in the traumatic in the golden period uh, provision, he is eligible to get the 5,000 rupees per accident. If two-person is helped to two different person in the case of accident, both the person is eligible to get 5,000 rupees as a compensation. It has been introduced to make this provision or make this good Samaritan or the golden hour scheme fruitful and to save some life in the future. So
Who will pay this 5,000 from that fund?
it's a government will government will pay. RTO is a notification from the MORTS, Ministry of Road Transport and Highway. He is going to pay the 5,000 rupees. That scheme is there. I think I have covered this that the you may get the this screenshot of that the notification further. So section 185 driving under the influence of alcohol or drug. I have written that the content of the alcohol or drug in the blood should exceed 30 milligram per 100 ml. Question may arise from here, sir. 30 milligram per 100 ml of blood if someone is detected in breath analyzer lab test that is having that the 30 milligram of the alcohol or drug in 100 ml of blood is incapable of exercising proper control on the vehicle. So in that case, if section 185 is charge sheeted, in that case only we can repudiate or we can this thing we can contest the matter on this part. There is a breach. So what are the punishment? Punishment for first offenses, imprisonment up to 6 months or 10,000 rupees or both, or for second offenses it is 2 years or 15,000 or both. So that is a section 185 all about. It is an important section you need to remember. I find may came in exam, but it is an important 30 mg per 100 ml of blood if it is there. If blood analysis report is less than 30 mg, you cannot dispute the claim on the basis of drunken driving case. Is it clear, sir?
Yes, sir.
So now, section 187, the driver or conductor of motor vehicle is accused. Yeah, in this case, if owner of the vehicle is not cooperating with the police authority, sometimes you find this section 187 is charged on the charge sheet. That is someone he is hiding the himself or the driver or not cooperating with the police authority. In that case, section 187 is charged. So some important section of IPC that is usually being available on the face of the charge sheet. That is section 279 for rash driving. You just go through that. You should question may not came from here, but some section may came. 337. I was repeatedly talking about the section 337 and 338. So 337 is causing hurt by endangering life of person. Safety. Section 338 is causing grievous hurt by act enacting life personal safety of others. So this section 338 is important. That is telling us that the nature of injury is grievous. So claim applicable for either for no fault liability or under WC claim. This section 338 is important in case of injury. In case of fatal, you will find the section 304 alpha. That is a causing death by negligence. If it is a fatal injury, you will find this 304 alpha. Recently, we find 304 2 causing death. Individual knowing his act may cause the death, but there is no intention in that death. Someone is driving a vehicle in the in so much negligently that he is knowing if someone is someone hit by my vehicle, he will definitely got injured and it will resulted into the fatal injury. So he is knowing, but there is no intention that I am going to kill the someone that the particular person only. It may be someone else. So that the section 3042 302 is punishment of murder or causing death intentionally. Why I have written this section? Because you should know the difference between 304 alpha and 302. If the charge sheet is telling 302 claim or anything is not payable, only 304 alpha is there. That is a negligently causing death by negligence. That claim is payable. We can. So one more section is 427. We are usually seeing this 427 mischief causing. damage amounting of rupees 50. So this is the Consumer Protection Act. Ma'am was telling about that. A consumer can file the compensation within 2 years. This timeline is you need to mug up that the timeline is 2 years. Provision is there for condonation of delay. After 2 years also delay can be filed. Geeta, can you mute? Geeta, ma'am, can you mute? Yes. So consumer can file complaint within 2 years, but still there is a provision for condonation of delay. Jurisdiction where consumer can file, where the claimant reside or work, where opposite party as the insurance company reside or work, or at the place of transaction where the OD is repudiated. So district commission is there. Amount in dispute is up to 50 lakh. Appeal can be filed within 30 days. Here clearly I have written, if appeal is arising out of the district commission for the state commission, it should be filed within the 30 days from the date of order. And in this case, appellate authority is a state commission. Subjected, there is a condition, 50% of the award amount to be deposited before filing the appeal. Clear, ma'am? A state commission is there for more than 50 lakhs but less than 2 crores. So any it is a disputed amount. Any dispute which is coming more than 50 lakh and up to 2 crore, it is directly go to the state commission. State commission is consisting of 1 president and 4 members. Appeal can also be filed within 30 days from the date of order. Wait. No, here it is a 45 days. I need to correct. It is a 45 days. I will correct and share the slides so you will get. Here the appeal from the state to National Commission, that will be filed within 45 days. Earlier there was a question from state to National Commission. If appeal is arising out of the order of the state commission, it should be filed within the within 45 days. Clear, ma'am? Appellate authority in this case is National Commission. In this case also 50% of amount to be deposited before the state commission or before the commission which has awarded the amount. So in this case, appellate authority is National Commission. So National Commission, more than 2 crore rupees all over the claim disputed amount will be there in the National Commission, and an option of second appeal is also there, and mediation has also been therefore given the statutory status. Mediation is also there, like we are having the Lok Adalat provision for MSCT case. So mediation is also there in Consumer Protection Act, that is a 2019. Should I move ahead?
The national to like
45
High Court
days.
and all.
National
No,
to
further,
High Court.
national to further.
Excuse me, sir. I have a question, sir.
Tell me, sir.
Sir, appeal, the age of appeal from DSRDC to State Commission is 45 days, as in the Act.
Sir, we need to cross check. I have.
Yes, sir, it is 45 days.
It is 45 days.
45 days, and then it is 30 days. 30 days.
Okay.
District to state 45, state to national 30, and
yes.
national to high 30.
30,
45,
yes.
30, 30.
If I'm correct.
Okay.
Yes.
Okay. So I need to change the first one, 30 to 45. Okay.
Yes, sir, 45.
45 only, and remaining are correct.
Okay. So, ma'am, as someone has clarified,
National to
High Court it is 30 days. 30 days.
30 days.
Yeah. Someone has concluded that the first one is the 45 days, district to state, and the state to national it is 30. Then the national to High Court it is 30. So now ombudsman appointment by the GI Council only. Presently there is 19, I think, ombudsman. It is appointed by for 3 years up to the age of 65 years. Yes, sir.
Sorry to disturb, sir.
Tell me, sir.
Sir, once again, please clarify these appeal, these timelines, please. District to
Sir,
state.
as clarified by someone, I need to confirm again. But as we conclude that the district to state commission it is 45 days, then the state to national it is 30 days, or national to high court it is 30 days.
Okay.
Okay. So, ombudsman appointed by GI Council for 3 years up to the age of 65 years age. Ombudsman, the area of complaint, what are the area which can be referred to the ombudsman? That is the partial or total liquidation of claim, dispute with regards to premium paid, dispute on legal construction of policy wording. Our policy wording is there if there is a dispute. Delay in settlement or non-issuance of policy after the receipt of premium. I think the last one is not. It is we are issuing the policy once we receive the premium. Matter can be referred for amount in dispute not exceeding 30 lakhs. So district commission is 50 lakh. Here it is 30 lakh. Condition should have filed complaint against the insurer and not receive satisfactory reply. What is the condition before going to ombudsman? He should file a complaint to the insurer and not get the satisfied reply. When he up to what time he can file the complaint before the ombudsman? Not made later than 1 year of reply of insurer. I have repeated and I have replied so up to 1 year he can go to the ombudsman. Same complaint should not be pending at any court of law. If any he has approached to any consumer or some arbitration anywhere it is there, so application is not sustained before the ombudsman. So recommendation: after deciding the case, ombudsman shall make aware the insurer as well as the complaint about the recommendation within 1 month. Once he receives the application, ombudsman he will give his recommendation and inform both the party. Claimant has to reply within 15 days. So after receiving the reply of the claimant, within 3 months of the date of receipt of complaint, ombudsman shall pass an order. So who can challenge? Insurer cannot challenge the recommendation of the ombudsman, but claimant can challenge before the consumer forum or other forum if it is if he is not satisfied with the recommendation of the ombudsman. What are the duty of insurer in this case? He has to inform the policyholder regarding the ombudsman in whose jurisdiction his office falls. An individual can only lodge the complaint before ombudsman. Claim lodged by the corporate client does not come under the purview of ombudsman. Anything about the ombudsman? I have covered, I think, everything in this ombudsman. So this first screenshot is their Motor Vehicle Amendment Act that was came
So
on the
one
9
question.
August 2019.
Sorry, sir. One question.
Just a minute, sir. Just a minute, sir.
Yeah. Yes.
Then this is the National Insurance versus Pranay Shetty that has came in 2017. I was repeatedly telling 2018, but it is a 31st October 2017. Here they have told about the future prospects. What are the future prospects applicable? One is for self-employed or fixed salary. There is a confusion. If it is a fixed salary, he is having the permanent job. So we should take in this. So we should not get confused. It is for permanent job. We are having a permanent job. But fixed salary, you may have a contractual worker, you may have the security guard and all, who is on the fixed salary where there is no provision of DA and all. So this is known as the fixed salary. So this provision is there. Now it is for the earlier 163 alpha. I have told you 5 lakhs for fatal, 5 lakh plus percentage of disability, and in minor injury there is a provision of 25,000. So it is as per the government notification, MORTH notification 22nd May 2018. So this is for the Employee Compensation Act has been revised and it has been the wages has been revised and it has revised to 15,000 by this notification that the date is 3rd January 2020. So any claim application which is coming after 2020, it will be treated as a minimum wages of the this employee will be 15,000. So this another is MORTH. Yes, this notification has come on 5 April 2020, where the renewal of certificate of fitness is there 2 years for vehicle up to the 8 years of old, 1 year for the vehicle older than 8 years. So this is the notification which has came for the fitness certificate. So now we have concluded. If any query is there, you can ask for another.
Sir, yes, sir.
Yeah, tell me.
Sir, I have one question. Yeah, sir, regarding just now, as you said, under the Minimum Wage Act that has been passed from the 3rd of Jan 2020. So you just said that any application received after 1st of Jan 2020.
Right.
So
First,
whether,
3rd
yeah.
Jan. I think it's 3rd or 4th Jan.
I'm sorry, 3rd Jan. Yeah, I'm sorry, 3rd Jan 2020. So whether it will be a date of application or whether
Date of
the policy
accident,
has
sir.
to be
Date of accident, sir. Accident,
Okay, so
accident whichever occurred after 1st Jan 2020, it will be applicable.
okay, so if the policy is issued prior to the 3rd of Jan, and if the minimum wages have been considered while issuing the policies at 8,000, so then whether the claim will be settled on as per 15,000 or 8,000?
Sir, you are talking about the policy issued under WC Act.
WC Act, sir, yeah.
Not the claim which is arising out of the Motor Act.
No.
No, sir. This minimum wages has been revised.
Okay.
And it is revised from the 3rd January 2024. So there is a provision of you can enhance the premium, you can get the premium, but for the policy which has awaiting for the lapses up to after that period, you should take the premium and it should be revised.
Okay.
We
And
cannot
secondly,
dispute
sir,
the,
okay.
yeah,
And so one more query was this regarding the application to the ombudsman. If a claim is rejected, so the insured can directly go to the ombudsman, or first he has to come to the grievance department of the insurer and
insurer. Yes, sir. He has to make the application first to the grievance department. He has to make the complaint to the insurance company. Then, if he is not giving the satisfactory reply, he will go to the ombudsman.
But he can but he cannot directly approach the ombudsman.
No, sir. There is no. There is a condition that he should made a complaint first before the insurer. Then he can go to the ombudsman. Or there is another condition. There should not be any arbitration or case pending before the tribunal for the same cause.
Sir, one question, sir.
Tell me, sir.
Regarding
ma'am, your voice is coming. Someone switch on the mic. Please switch off the mic.
Regarding
tell.
Devanshi ma'am, please mute your mic.
Difference in quantum.
Yeah.
How
difference
many days,
in quantum.
how many days he will apply for arbitration?
Arbitration. How many days? Your question is not clear. So tell me again.
No. We have settled the claim for 30 lakhs.
Yeah.
Against 1 crore. The insured
70 lakhs is there.
The insured has challenged in for arbitration. That is why the difference in quantum is there.
70 lakhs is there, no difference. So where he will go? He will go to the state commission.
No, arbitration is challenging against arbitration for appointment of arbitrator.
Okay.
How many days after settlement of the claim?
Sorry, sir, I don't have. I have not covered the arbitration, and I don't have actually the idea about the
Within 30 days. Within 30 days.
No, sir, that is not there. After settlement.
So definitely it will be.
Devanshi, एक मिनट sir. Devanshi ma'am.
Yes.
Please mute your mic, please.
Sir, definitely I will let you know, sir. I will post this query regarding arbitration and all in the group.
Right, sir. Thank you.
Any other queries, sir?
So whether there are any chances of asking the questions that what were the provisions under 1988, that is the MV Act 1988, and the one which is amended in 2019 or applicable from 2022, sorry.
2090 amendment is there, sir. So question may come as per the new amendment.
Okay.
But question will be direct mostly. There should not be. It will be clear, sir. Clear cut question is there. He is not going to ask to the particular section. Some section which is important, he may ask about the DL, which is all the important section. But rest other you should need the provision. What is the provision in that section?
Sir,
Yes, ma'am.
so if the claimant is not satisfied by the ombudsman award, then can he go to the district commission?
100%. There is he can go. Insurer cannot dispute the recommendation of ombudsman, but I have told
But-
I have written there. He can go to consumer forum.
Okay. Okay.
He's free to file the claim application.
Okay.
सर
Yes, sir.
डिस्प्यूट इन क्वांटम ombudsman में 30 लाख ही है या कुछ रिवाइज हुआ है?
30 लाख ही है सर, लेटेस्ट तो
30 लाख ही है.
Right.
Okay.
If still any there changes, I will let you know. I will post these two query, ombudsman changes and another one is the arbitration. So let's conclude today's meeting.
Yes, I would like to thank Breej Mohan sir for such a wonderful lecture. Basically, all the other subjects, sir, these are only applicable for our professional life. But I think motor TP is the only subject which is applicable for in our social life also. See, whatever
Right.
provisions of the Motor Act, we can tell our friends, our relatives also. So,
Right.
which will be very helpful for other people also. So, it was very nice to interact with you, sir. It was very wonderful lecture. Deepak Malik ji, आपका वीडियो बंद कर दीजिए ना. So I really thank you all the participants for listening very patiently to sir, and definitely sir has covered almost entire topic which have been asked in the past in the examination in the past, and he has covered everything. So I think with this you will be able to crack your exam with very flying marks. So wish you all the very best, and I request those who are appearing for the first time can wait for some time, so that we can talk about the examination. Those who are appearing for 2 to 3 and 3 to 4, they can leave, and if they want to attend, they can also attend. But those who are appearing for the first time can wait. Shall I continue, or you want to end the meeting?
No, sir, we'll continue. We can discuss some points.
Those who are,
Sir,
sir, you are leaving, na? You are leaving, na?
No,
Breej Mohan,
I am
sir.
not leaving. I am not leaving, sir. I am also the one of this aspirant for the first time.
Actually, I desperately didn't tell. I desperately wanted to tell all the participants that he, appearing for the exam, sir has spared such a valuable time for us. In spite of studying himself, he has allotted this 3 to 4 hours for all the participants. So again, once again, I thank you, Breej Mohan sir, because in spite
Thank you, sir. Thanks a
studying,
lot
he came here for
providing.
benefit of all the students. So thank you very much. So those who are appearing for the first time, the question paper is very simple. The question paper, the last 2 years I have been following this exam. Last year I was one of the participants. I have appeared last year. So what I have observed in last 2 to 3 years, the question paper is very simple, but the options are very tricky. The options are very tricky. So all the 4 options, you will find that this is correct, or you see almost all the 3 options. लगता है कि सर वही correct है करके. तो आपको क्या करना है ना कि आपका जो बेसिक, यू नीड टू बी वेरी केयरफुल, योर कंसेप्ट शुड बी वेरी क्लियर. If your concept is very clear, now then you will be able to answer very clearly. And nowadays what happens, there are a lot of study material, you are flooded with a lot of study material. So my humble request to all the people is you stick to the III books only. III books and the PPTs which have been prepared by our faculty members like Breej Mohan sir hai, Pratik sir hai, गीता मैम थी, या इवन सीडीआरएल के जब बेग सर थे. तो the PPTs have been drafted in such a wonderful manner that everything is been taken from the III books only. So you can 100% rely on those PPTs. And the question banks which are available in the market. So many people are floating question banks on the books or either online basis. So many a times what I have observed there are many mistakes in the question bank. The options which have been given in the answers which have been given in the question bank, so those are not correct. So don't blindly follow those question banks or the answers given. The questions may be good, but the answers may not be correct all the time. So what I personally feel, suppose if you are not able to find the answer for your particular question in the bank, so you go to like suppose what is the excess for the fire policy. If the question is answer is not available in the question bank, you go to that particular tariff or the textbook given textbook of AAA, you find answer yourself. Then that answer will fit into your mind permanently. You are getting me what I'm saying, sir? Everyone?
Right. Right.
Huh?
Yes, sir.
So last year when I was appearing for this exam in the so-called this online exam, I found so many answers wrong. So I had to visit to the III books or any the IRDI circulars to rely upon that. And secondly,
Our
see,
tariff is also correct one, na, sir.
yes,
Tariff can also
tariff.
answer.
Yes, sir, tariff is also correct. Tariff is also correct. But the tariff, there are certain what do you say, amendments which have come to the tariff. Like a motor OD, there is one last also Pratik sir also discussed. For
Right.
vintage car is the only exception in the tariff where third party portion we give the discount. So there in 2009 or 11, I don't remember the exact date. So revision is come in the tariff. That circular is available on the IRDI side. So those references we have to see. Okay. And the question, the most important thing, you have to decide what is the score you want to score. What I have seen in the past 10 to 12 years when I have been following this exam, there is only one ma'am, Priyanka ma'am was there. She was the only lady who has scored 100 out of 100 marks. Otherwise, I have never seen even a single person scoring 100 out of 100 marks. Priyanka Prabhu was the only ma'am. She has scored 100 out of 100 in scale 1 to 2. Otherwise, nobody has scored 100 out of 100. So my humble request, don't attempt 100 questions. As there is a negative marking, you don't have to attempt 100 marks for scale 1 to 2 and 2 to 3. I think comfortable score for getting promotion is 80. If you solve 80 marks, if you are 100% sure that you can score 80 marks with solving only 80 questions, then solve only 80 questions. Unless and until you are very 100% sure your 100 questions are going to come correct, then only you attempt 100 questions. Otherwise, don't try to solve 100 questions. For scale 1 to 2 and 2 to 3, you can comfortably, if you score 80 plus marks, you are comfortably in the promotion zone. And if your CR is 100% right, outstanding, and there is no audit query or any vigilance query, with 80 marks, you are comfortably in the promotion zone. One more thing, while answering, when you are reading a question paper, when you are reading a question, read the question very up to the last word. Normally what happens now, we read question halfway and conclude, we jump to a conclusion that this will be the answer of the question. So don't do that. I have been committing mistakes in my examination. So on the basis of that, I am telling you, you read the question carefully, full question you have to read, and then only decide upon a option which you are going to select. Normally what happens that these examiners are very tricky. The halfway of the question is a different, and 50% of the question is a different thing. And that in order to confuse you, they frame a question in a such a way you jump to the conclusion after reading first 50% portion only. So don't do that. Read the question very carefully up to the last. Then only you click the option. Secondly, what happens? There are 4 options: A, B, C, and D. Our heart said something, and our hand clicks. We have to click A, but our hand goes there, and we click the C. So that hand-eye coordination also you need to be balanced. So just see that when you are answering the question, what is your in mind and what you are clicking is the correct one. So these are the mistakes which I have been committing. So I don't want you people to commit the same mistakes. So I am telling you. And I think in fire and motor, our faculties have done an excellent job. Nothing will come outside this presentation or their lectures. So for motor and fire, you can rely upon our lectures. Anything else you would like to ask about the examination? You can ask.
Anil sir, this is Durgesh here. I will be appearing for scale 2 to 3.
Right.
So whether problems for motor or even for TP for that matter, whether a problem is calculation part is there, motor OD I can understand, but for TP also does it come?
No. What I have seen in the past, up to last year, I have been observing these examinations. No, so largely the question comes in the OD part only, motor OD. They have never asked calculation in motor TP, except that Pranay Sethi and Sarla. What is that case?
Sarla Verma.
Sarla Verma. These are the two cases where they have asked they are the direct question. What is the compensation payable in that case? Otherwise, except OD, they don't ask any numericals in that on TP part to calculate the loss payable. Only OD portion. There will be in OD portion. There will be at least 5 to 6 questions, as Pratik sir has rightly said. At least 5 to 6 questions will be there on OD portion.
I am also sure, sir.
Okay,
Numericals will not come from this TP because it is not a practicable.
Anything else? And see, in 100 minutes, we have to solve how many questions? 120. We have to solve 100 questions, right?
100 questions, right?
So approximately 1 minute, less than 1 minute per question.
Yes.
So it won't be possible. Even while drafting the question also, they draft in such a way or numericals key you will be able to answer within 50 to 60 seconds this numerical. Like that they frame their questions. So it won't be. You don't try to spend much time on the numericals. No doubt, numericals is very important part because numericals, when you do your numericals correctly, you will get 100% marks. So numericals are.
Calculator is allowed in the exam?
Yes, online calculator is allowed. From last year, they have started allowing online calculator. It will be available on your screen only. Personal calculators are not allowed.
Okay.
Last year, they have allowed on the on-screen calculator. We can calculate there. But there is one thing. The questions which are there in the exam now, they don't really need calculators. By simple calculations, we can calculate those numericals. Anything? Last year, other than motor OD, there were some numericals on reinsurance 3 to 4, scale 1 to 2 and 2 to 3 and 3 to 4 also. See, basically, scale 1 to 2 and 2 to 3 people, the questions will be very simple as compared to 3 to 4 and 4 to 5. Okay. Anything else?
Anil sir. Hello.
Yes, tell me.
So, जैसे आपने बताया भी just last year only you have been through this exam. So, can actually you guide on what kind of questions do appear in all of these sections? Like, अगर fire है तो उसमें.
Ma'am, you are there in our group, WhatsApp group, Telegram group.
So it's posting continuously.
I have joined today morning only.
Acha, you can scroll down, scroll up. Then I have posted few questions in the group. Telegram.
Okay.
I think many of the people may be knowing that.
Okay.
Have you seen those questions? Anybody?
I have seen so many questions.
Sir. Basically, questions which I have been posting in the group are the questions asked in the previous year's examination.
Okay,
sorry. Excellent question has been said.
Okay. So basically,
question has been said, sir.
Okay, basically these are. I don't remember the question actually. I remember the concept. On which concept I had asked the exact question. So I just framed the question on that basis, and similar questions have been asked in the examination.
And the answer pattern has also been improved, and we are very much satisfied with the answer pattern.
Answer pattern, I didn't get you, sir. What do you want to say?
Yeah, your answer pattern, when I am clicking, I am getting the right answer by seeing that number of percentage of correct answer has been given.
Okay. Because I have given the correct answer also in
very
the group.
Fine. Yes. Very fine, sir.
Thank you very much.
Sir, is there any
technical-
miscellaneous class in future?
Yes, there will be a miscellaneous class also. There will be a reinsurance class also, and there will be a marine class also. Next Saturday, Sunday, we are planning marine classes. Hello.
Sir, it will be beneficial if you
Yes.
conclude in reinsurance classes first.
The reinsurance, yes.
Yes,
That
reinsurance.
is much needed.
Reinsurance
That
also
is much
actually. Reinsurance was scheduled on coming tomorrow and day after tomorrow, but due to some unavoidable circumstances, the reinsurance classes cannot be taken on Monday, Tuesday. But definitely, the reinsurance class will be there, and I think for scale 2, they will be designed for scale 1 to 2 and 2 to 3 basically. Plus, scale 3 to 4 and 4 to 5. There are some decision-making questions asked in the reinsurance. The basic will be cleared in our lectures, but for 3 to 4 and 4 to 5, largely these people everything knows. Everything it is considered that 3 to 4 and 4 to 5 everything is known by those people. So the difficulty level is little bit more for 3 to 4. The numericals will be little bit difficult for 3 to 4. Reinsurance class will be taken. My personal request to all the participants, those who have any queries in the reinsurance subject. I'll be taking reinsurance class for you people. So whatever queries you have related to our examination only, you can post it in my personal Telegram number, so that I will cover all those. I will reply to those queries while giving the lecture. In my lecture, I will cover those everything. Whatever you have queries for reinsurance, please post it. Don't post it in the group. Post it in my personal Telegram chat. I will try to cover all those queries in my lecture. Okay.
Thank you very much, sir.
Okay.
So
The
if you have any queries,
miscellaneous class will be conducted on next weekend.
yes, Kaustubh Kulkarni sir will be taking our miscellaneous lecture. Most probably there will be 2 lectures after. There will be scheduled in the next week around say 7 to 9 p.m. Tuesday, Wednesday, Thursday, Friday, or Saturday evening. And everything information will be shared in the group.
Okay.
Okay. So wish you all the very best. I once again thank you, Breej sir. Breej sir is such a special person for us. Thank you, sir, for sparing your time, and wish you all the very best, sir. Also, in case if you have any queries, you can post it in our group. You can ask us. Okay.
Definitely,
Thank you
sir.
very much, sir.
Okay, sir. Thank you. Thank you so
you
much.
everyone for listening me.
Okay, we'll
And,
conclude for the day. Thank you very much.
Right.
Thank you,
Thank you,
sir.
sir.
Thank you so much. Thank you.
Okay. Breej sir.
Right, sir.
Sir, you can end the meeting because you are the host.
Okay.
So you can go to the leave and end meeting. At the right hand, the bottom. Right hand bottom.
Leave meeting, na?
Leave meeting and end meeting. Is there any option for the end meeting?
Just a minute. Stop live streaming. Stop recording for the reaction. Just a minute. Leave meeting.
Leave meeting is there because I think you have logged in from 2 IDs, na sir?
2 devices. Right, sir, right.
So where you, in one your admin host. Can you see?
End meeting.
Breej
And is there. And is there. And is
yeah,
there.
so you can end the meeting, sir. Yes.